Almost, sir.
You want me to open it right now? I'm not gonna open it right now. No, she could do it. Yeah, she could, if she has a, put it back into the seal.
Well, we have just evidence tape up here, right?
Yeah, we do. Yeah, we do.
So is that what yours?
Is it one that she initially logged in?
Yes.
Oh, we should probably just have her do this so we don't have
That's
to.
fine. I just didn't know if you guys were preferring during trial, only these guys doing that, that's all. Okay.
Speaking of unsealing things, when Aaron Horowitz was on the stand, we introduced the knife.
On the record, it's 8:25. We're in Division 11 of the Weld County District Court. We're here regarding People of the State of Colorado versus Kevin Eastman, 20 CR 461. We're outside the presence of the jury. The parties are all present. And is the prosecution intending to call any witnesses when the jury arrives?
Yes, Your Honor. We are intending to recall Darcy Fedak for a few short questions and introduce 2 new photos through her, and then also recall Sergeant Porter and ask him a few questions as well. They are both short, at least from the prosecution's perspective.
Okay. And then you anticipate to be resting?
Yes.
Okay. And we'll then have to take another break just so we can do a Rule 29 motion and a potential Curtis advisement.
Great.
Anything else before? I'm having regrets telling the jury to come in at 9 o'clock since we're running for them now, but it is what it is.
Oh, that's right.
Judge, I don't have an objection to doing the Curtis advisement now.
Before the prosecution rests?
And if we just, yes, in terms of the court giving the advisement, and then we would ask for a break to meet with Mr. Eastman in private and then make the decision later. But in terms of just actually the court telling the advisement to Mr. Eastman, we don't have an objection to using this time for that now.
Are you okay with that, Mr. Rowan?
I am, as so long as the defense is waiving any irregularities as to the order of things.
That's fine.
Okay. And if you would like me to advise
I mean,
him?
in terms irregular, you're talking about just for the purpose of the Curtis advisement, right? Yes, that's fine.
And if he wants me to give him another advisement, the same advisement again, I'll be glad to do so, but at least now he would be able to think about what I said. Before I do that, I need to know the status of count 7, possession of a weapon by a previous offender. It would affect my Curtis advisement.
People would move to dismiss count 7, which had previously been bifurcated from this proceeding. in the interest of justice, due to the procedural confusion that count would cause in a multitude of ways.
Any objection?
No.
So count 7, possession of a weapon by a previous offender is dismissed at the request of the prosecution. So Mr. Eastman, I appreciate you paying close attention throughout these proceedings. I'm going to be giving you an advisement as it relates to your right to testify or right not to testify. Typically, I give this advisement after the prosecution rests. Sounds like the prosecution is going to be resting very soon this morning after 2 brief witnesses. But for the sake of time, I will give you the advisement now. I don't expect you to give me an answer when the prosecution rests. If you would like me to re-advise you, I'll be glad to do so, but at least now you'll have time to think about what I said and discuss the issue with your lawyer, okay? And I'm going to have you talk into a microphone so that way we can have a good record.
Yes.
Thank you. You could, I think if you just position the microphone in his direction, it would be fine.
Sorry, I have a moment to arrange some wires. Thank you, Judge.
Okay, so first, you have the right to personally testify as a witness in this case if you choose to do so. If you want to testify, no one, not even your lawyer, can prevent you from doing so. Do you understand?
Yes.
Second, if you choose to testify, you will not only answer questions asked by your lawyer, but you must then answer questions asked by the prosecutor. Do you understand?
Yes.
Third, if you choose to testify, jurors may submit questions to the court for you to answer, and the same rules of law, evidence, and procedure that apply to lawyer questions will apply to juror questions. Only legally proper juror questions may be asked. Do you understand?
Yes.
Fourth, if you choose to testify, and if it happens to be a fact that you have previously been convicted of a felony, the prosecutor would then be entitled to ask you about it and thereby disclose that fact to the jury. However, the court would then instruct the jury that they may only consider such prior felony conviction for the limited purpose of whether or not such a felony conviction affects your credibility as a witness in this trial. The court would also instruct the jury that a prior felony conviction may not be considered by the jury as evidence of guilt in the present case. Do you understand?
Yes.
Fifth, if you decide that you do not want to testify as a witness in this case, no one, not even your lawyers, can require you to testify. If you choose not to testify, the court will instruct the jury that they may not consider your failure to testify as evidence of guilt. Do you understand?
Yes.
And sixth, it is the responsibility of your lawyers to give you advice as to whether your lawyers believe you should or should not testify as a witness in this case. You should listen to and consider your lawyer's advice, but it is important that you understand that you are not required to follow your lawyer's advice. Do you understand?
Yes.
Do you completely understand everything that I've said?
Yes.
Do you have any questions about anything I've said?
No, sir.
Thank you. So think about that advisement. When the prosecution rests, I'll be asking you again if you would like me to re-advise you. And if you say yes, I'll be glad to do so. If you say no, then I'll be asking you for your answer. If you want to have some time to discuss that with your lawyer, you don't have to answer that question before you present any evidence. But before your lawyer rests the defense case in chief, I do need an answer from you. Okay?
Okay, thank you.
Thank you. Any other advisement you would like me to give, Ms. Devereaux?
No, sir.
Okay, all right. We'll be in recess for a little while, and we'll get started with the jurors. If the jurors happen to be here early, do you want to get started early?
Sure.
Or are your witnesses available?
Because the jury was coming back at 9, we asked Ms. Vidak to be here around 8:45.
Okay, so if everybody's available, we'll get started a little bit early, okay? Okay, thank you. All right, we'll be in recess until we're ready to proceed.
No, no media.
That's what I was kind of,
I can do that right now.
not a problem. So just call him.
Yeah, we'll do that right now. You ready?
That's what's coming
Can I
up.
bring my coffee?
Yes. As long as you don't take me with it.
We wasted your coffee.
We're gonna hit that.
Do I have to call you?
Please. Slide this out.
Do you need me to bring my computer? Oh, I got mine.
Ashley, I know you had, did you want to look at the two photos we're introducing through FIDA?
That's, will be same.
Okay.
Yeah.
Are we off camera? Yes, sir. Okay, thank you.
Sure.
We didn't get invited.
No. I'm rare. It's been a lifelong thing.
Your prior colleagues who sat there weren't as prepared.
That's been the big turn.
Really? Really? I don't remember Asher sitting on it. Maybe he was just too big. I didn't see it. I didn't mean it like that. I didn't mean it like that. I did not mean it like that. Please don't.
That'll go in the public.
Oh, Lord. Cheryl, you inspired me this morning to remember to put some, what's that peppermint cream on? Yeah, on my bag. Because I remember you talking about peppermint. I was like, oh, I had like a little sample, so hopefully that helps tonight. But yeah, yeah. I broke my coccyx and my sacrum back in like before law school, and then having like a very large baby, everything just hurts.
Okay, now we need to prosecute. And,
She weighed 9 pounds, 7 ounces. And it's funny because Ashley had her son a week before us, and he weighed the exact same, even down to the ounces.
Okay, we are back on the record. I believe all the jurors are now present. All the parties are present, although we're currently outside the presence of the jurors. Any issues before we bring them in?
No.
Okay, let's all please rise when the jurors come in.
Please rise.
Morning. You're welcome to be seated. Okay, we are now in the presence of the jury. It's 9:03 a.m. On July 15th, prosecution may call or recall their next witness.
Thank you, Your Honor. The people recall Darcy Fedak to the stand.
Good morning. Welcome to resume the witness stand. And I'll swear you in again, given the lapse of time. And do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth? Thanks. Why don't you have a seat, make yourself comfortable. Again, feel free to adjust that microphone. I know you've already introduced yourself to the jurors, but why don't you go ahead and just state your name again?
My name is Darcy Fedak.
Thank you. You're welcome to examine.
Thank you, Your Honor. Good morning, Ms. Fedak.
Good morning.
I want to take you back to the search that you conducted of Heather Frank's apartment in Greeley, starting on February 16th, and then you had previously testified that that continued into the 17th. Is that correct?
That is correct.
I want to show you a couple photographs, if I may. May I approach, Your Honor?
Yes.
I didn't previously show counsel. I'm showing you what the marked for identification of People's Exhibit 236 and 237. I'm actually going to take them in reverse order, starting with People's Exhibit 237. Do you recognize the scene depicted in that photograph?
I do.
What do you recognize that to be?
The scene in People's Exhibit 237 is the east side of Ms. Frank's couch in Ms. Frank's living room. And there is a Walmart bag marked with evidence marker number 11.
And I believe you previously testified that you had searched that bag and you had found some packaging inside of that Walmart bag. Is that correct?
That is correct.
And what kind of packaging was inside that bag?
Inside of that Walmart bag, there was packaging for a Samsung A10e, as in Edward, cell phone, as well as a Walmart receipt.
Was the phone in the packaging?
It was not.
Had the packaging been opened?
It had been.
And then people would offer 237 into evidence.
Any objection?
No.
237 is admitted.
Then if you could review People's Exhibit 236 and tell me if you recognize what is depicted in that photo as well.
I do.
What is it?
This is the packaging for the Samsung A10e cell phone that had been opened. That was inside of the Walmart bag. The front flap of the packaging is reflected open so that I can now see the Walmart receipt for an item that was purchased at Walmart, and the total purchase was for $153.02.
How many items were purchased?
I see a purchase for 2 items, one that was $99 and one that was $45.
And based on the receipt and the packaging, can you tell what those items might be?
One of the items has a product serial number, and one of the items does not. Based on the location of the receipt, the price, and the serial number, the conclusion was made that the receipt was most likely related to the...
Speculation.
I'm sorry, I couldn't hear that. Objection is what?
Speculation.
Sustained.
Is there a, well, you said it's a Samsung phone
Correct.
that the packaging involves. Is there a reference on the receipt to anything that you would associate with a Samsung phone?
The item number says S102C for one of the items that was purchased for $99, and a serial number is provided.
And that's the $99 item?
Correct.
And are you familiar with that serial number?
I am not specifically.
Okay. Is that a fair and accurate depiction of the packaging and the receipt that was located inside the Walmart bag that was next to the couch that was depicted in People's Exhibit 237?
I am, and it is accurate.
And people would offer 236 into evidence?
Any objection?
No?
236 is admitted into evidence.
Request to publish?
Sure.
And Your Honor, I'm going to ask to walk that around, or we just pass it around. We don't have that inputted into the program.
You want to publish both?
Yes, please.
Okay.
I have no further questions for Ms. Moore.
Let's just wait for it to be published and viewed, and then we'll start with cross-examination. Okay, you're welcome to cross-examine.
Thank you. Good morning again.
Good morning.
So to start, we all just saw the picture of the Walmart bag and phone case.
That is correct.
And the picture also depicted a receipt from Walmart.
Yes,
And that item or that photo was taken within Ms. Frank's residence.
that is correct.
And during your search of her residence, it's probably obvious you located a majority of the items, or the majority of the items that you located in her residence belong presumably to her.
Objection calls for speculation.
Would you be guessing or speculating by answering that question?
I would be speculating.
So I'll sustain the objection.
The Walmart receipt that we see, or the receipt from Walmart that we see in the bag, you do not know who purchased that phone.
That is correct.
You do not know if Ms. Frank purchased that phone.
That is correct.
And I'm going to show you. What's been previously shown to Mr. Wren and has been identified as defense exhibits, or proposed exhibits, triple J and triple K. And along with the search warrant that you helped execute at Ms. Frank's residence, you also assisted in the execution of one of the search warrants for Mr. Eastman's vehicle.
That is correct.
And you recognize the exhibits I just presented you because those are two receipts that you located in his residence.
Yes.
I'm sorry, in his
I'm sorry.
vehicle.
Yes.
Thank you. And let's start with defense exhibit triple J. Do you recognize what that particular receipt is for?
I do.
And what is it?
These are receipts that were for an old Chicago purchase in Longmont that were dated February 12th, 2020, that were recovered from the front center dash pocket in the Subaru Crosstrek.
And are those fair and accurate depictions of the exhibit, of the receipts that you've collected from Mr. Eastman's Subaru Crosstrek?
They are.
At this time, we would move to amend defense exhibits, or triple J.
Any objection?
No, Your Honor.
Triple J is admitted.
And likewise, triple K, is that another receipt that you located in Mr. Eastman's Subaru Crosstrek?
That is correct.
And what is that receipt for?
This receipt is a Subaru Valley receipt for an oil change and tire rotation. This location is also in Longmont. It is also dated February 12th, 2020, and it was recovered from the dash of the Subaru Crosstrek.
And is that a fair and accurate depiction of the Subaru receipt that you found on the dash of Mr. Eastman's Crosstrek?
Yes, it is.
At this time, we move to admit defense exhibit triple K.
Any objection?
No, Your Honor.
Triple K is admitted.
And Your Honor, for triple J, I'm going to ask the witness to open the exhibit bag because you can't see the actual front of the receipt as it is, and have her repackage it. And that was something that the prosecution had asked to do it in front of the jury, so.
Do you agree that you can't view the contents of that receipt?
I agree.
Do you have the ability to reseal it after you open it?
If we have evidence tape,
We
I
do.
do.
Okay. Yes, why don't you need a pair of scissors?
Yes.
We'll get you a pair of scissors. Why don't you just, when you're doing it, just describe what you're doing for the record?
Do we also have a pair of gloves,
Yes,
Your Honor?
we'll get you a
Thank
pair of gloves. Please.
Thank you. I'm so sorry. Like those guys.
I am donating gloves to limit any potential cross-contamination of this item. There are 2 seals on this item right now as it exists. My original seal and a seal from the item having previously been opened. I'm going to cut below this seal, preserving this seal. And this previously existing seal is going to go in the bag so that it stays with the exhibit. And would you like me to remove the exhibit?
Yes, please, so we can put it in a new bag that the jurors can see. I need more coffee this morning, I apologize.
So in the original packaging, there are 2 previous seals, including the one that I just removed. And there are 2 receipts.
Can you repackage them, please? So that the Old Chicago and the date and location can be visible to the jury.
You want her to state on the record what that date is?
Yes, please. I think she already did, but just in case. Can you say the date on the receipt, please?
The date on both of the receipts is February 12th, 2020. One timestamp is 11:19 a.m. The second timestamp is 12:03 p.m.
Thank you. And just to clarify, both receipts are for the Old Chicago and Longmont, Colorado.
Yes, that is correct.
Thank you.
Would you like them repackaged so that both dates and timestamps are visible?
Yes, please.
Before I seal the bag, is this satisfactory?
Approach.
Sure.
Here's the date, time, location, date, time, location.
Thank you
Okay.
very much. I appreciate you asking.
And for the record, I am now using evidence tape to reseal the evidence packaging. And I will place my initials, unique employee number, and the date on the evidence packaging.
And you completed the process?
Pardon?
Have you completed the process?
I have.
Thank you very much for doing that. Your Honor, at this time, we would request to publish to the jury, please.
Sure.
And after it's been published, I don't have any further questions for this witness. Thank you, Ms. Vidak.
Will you be having redirect examination?
No, Your Honor.
Thank you. So if you wouldn't mind just waiting, because the jurors may have questions, but let them view that exhibit first.
day. Your Honor, while the jurors are doing that, can we go Bluetooth?
Yeah.
For housekeeping now?
We're going to do that after. Any questions from the jury with regard to this witness? Okay, you're welcome to step down. We appreciate your time. May she be excused from her subpoena?
She may.
Ms. Devereaux?
She remains under our subpoena.
Great. Thank you very much. Appreciate your time.
Thank you.
Next witness, please.
Thank you. People recall Gerald Porter to the stand.
Good morning. Good morning. Given the lapse of time, I'm going to swear you in again. And do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth?
I swear.
Thanks. Why don't you have a seat, make yourself comfortable. While there's no need for you to reintroduce yourself to the jury, if you can just state your name for the record again.
My name's Gerald Porter, Geraldporter.
Thank you. You're welcome to re-examine.
Thank you, Your Honor, and good morning.
Good morning.
Sergeant Porter. As an advisory witness, you have been present throughout the trial and heard the testimony, correct?
I have been.
Yesterday, there were some questions of CBI criminalist Madison Fisher, who did the firearms and tool mark examination. Do you recall those?
I do.
There were questions as to whether or not she was ever provided for analysis any bullets or casings that had been described as having been removed from the pants of Troy Bonnell. Is that correct?
That's correct.
I want to talk to you a little bit about that. As the lead investigator for the Weld County side of this investigation, have you reviewed all of the 139 reports generated by your agency in this case?
Yes.
And have you also had a chance to review almost all of the Larimer County Sheriff's Office reports in this case?
I would say the majority of the Larimer County reports, yes.
And have you also had an opportunity to review the exhibit list documenting all of the evidence logged in under this unique case number for the Weld County Sheriff's Office associated with this investigation?
Yes, I have.
And have you had an opportunity to view the same kind of evidence log for the Larimer County Sheriff's Office related to this investigation?
Yes, I have.
And anywhere in those records, does it document that ammunition was removed from Troy Bonnell's pants or person?
No, it does not.
Objection, hearsay, speculation.
Mr. Ryan?
No, it's offered in direct rebuttal to issue raised by defense counsel with an expert witness yesterday.
But he's seeking hearsay to say that like other officers did not remove or see the bullets when it's not the case. Those other reports clearly do say that. So I'm not sure like how this witness can testify to a report of a different witness or something a different witness said without it being hearsay.
It's not hearsay because there's no statement being offered in court because there's a lack of statements in those police reports according to this witness, so I'm going to overrule the objection.
During one of your conversations with Troy Bonnell, he made that statement, correct?
Yes, he did.
Okay. But do any of the police officers' reports document such a thing?
No, they do not.
If you had observed such items logged into evidence, would you have submitted them for analysis for firearms examination?
I certainly would have.
All right, moving on to a different subject. Have you had an opportunity to review the Facebook records that have previously been admitted in this case for Kevin Eastman or Kevin Quintana's Facebook account?
Yes, I have.
And those records were previously admitted as People's Exhibit 186, is that correct?
That's correct.
All right. In reviewing those Facebook records, is there an email address associated with Kevin Eastman's Facebook account?
Yes, there are two.
What are those email addresses?
chainhand72@gmail.com. And I'm sorry, that was the only one for that account that I remember right now.
Say that again?
chainhand72@gmail.com.
And you're saying chain hand, CHAINHAND, all one word as an email address?
That's correct.
And you were also present with criminalist Todd Zeitzwig, talked about downloading some data from a silver iPhone that was in a red case collected from Kevin Eastman's Subaru. Is that correct?
That's correct.
And that he identified as CBI item number 3.
Yes.
And he described providing that data to you after he downloaded some data from the phone.
That's correct.
And did you have an opportunity to review the data that he provided to you from that phone?
I did.
And were there email addresses associated with that phone?
There were 2 email addresses associated with that phone.
Mr. Zwetzig actually already testified to this. This is already in evidence. There was much testimony about that phone having 2 email addresses associated with it. And I even asked Mr. Zwetzig, what do you mean by associated?
So is the objection cumulative?
Yes.
Okay, what's the response?
This is foundational for an additional question related to when those email addresses were entered into that phone.
So unless you're waiving that foundational requirement, I'm going to overrule the objection. Are you waiving that foundational requirement?
I would say it's hearsay.
So I'll overrule the objection. You're welcome to continue.
Okay. So what 2 email addresses were associated with that phone found in Kevin Eastman's Subaru?
Troy Milo at yahoo.com was one of them. The other was chainhand72 at gmail.com.
And did the data that was provided by Mr. Zeitzwig indicate when those email addresses became associated with the phone that is People's Exhibit 135?
Objection, hearsay.
This is information that's already contained in the admitted exhibits?
Yes.
So I'll overrule the objection.
Do you need me to re-ask the question?
No. The first account, Troy Milo at yahoo.com, was signed into the iCloud on October 13th,
You're
of
not
2018.
an objection, hearsay. This hasn't been admitted into an actual exhibit.
The testimony was that he downloaded the data from the phone, that he provided it to Detective Porter, and that Detective Porter has had an opportunity to review that data.
Why is that not hearsay?
It's not an assertion. It's not an out-of-court statement offered to prove the truth of the matter asserted. There's no declarant.
The declarant is Mr. Zwetzig.
No. He downloaded data. The data is the data, as has been said.
So this is not a statement, this is data that's downloaded?
Yes.
And I'd also say this witness doesn't have personal knowledge of it. That foundation has been laid. Sorry. I would say that this witness doesn't have personal knowledge of that either. He's relying on what Mr. Zwetzig told him the data said.
Not told him what was downloaded from the phone that is the data.
So I'll overrule the objection.
And did you review the data provided by Mr. Zeitzwig as to when those 2 email addresses became associated with that phone?
Yes. As I previously testified, there's a program called Celebrite. And Celebrite is an extraction program that presents information from phone extractions. And that's how I was able to see the information.
And when did each of those respective emails become associated with that phone?
I already testified to the Troy Milo. I'll now tell you about the chainhand72 at gmail.com was December 22nd of 2018.
No further questions for this witness. Thank you.
Thank you. Any cross-examination on those limited issues?
Yes. So you just testified that to one date that the chain hand email address was associated with the phone found in Mr. Eastman's rear seat of his vehicle, correct?
That's correct.
And you were here when Mr. Zwetzig testified, and you know from your apparent review of the data that although the email address may on one day have been associated with that phone, the overall Apple ID associated with that phone was troymilo@yahoo.com.
There were 2 signed in, and those were the dates they were signed in associated.
That's not my
with the phone.
question. My question is the actual Apple ID controlling that phone, as Mr. Zwetzig testified, was troymilo@yahoo.com.
That is what he testified to.
And as the lead detective in this case, despite getting that information, you did absolutely nothing to get the records from apple.com regarding Troy Milo at yahoo.com.
I did not.
You also did absolutely nothing to preserve and get this jury the phone records for that phone.
That's correct.
You did nothing to obtain, including a search warrant, preservation request, to get the location data for that phone.
Correct.
And because you made those decisions along the way, this jury doesn't have the benefit of knowing whether or not that phone also traveled up and to and back the Poudre Canyon,
Objection argumentative.
Ruled.
Correct.
or if that phone also traveled back from the Poudre Canyon on February 9th.
I don't have that information.
And those are decisions you made as the lead detective.
Objection
Correct.
argumentative.
Overruled. What was the answer?
Correct.
Next question.
Thank you. You also testified to this jury as a lead detective who's been sitting through this trial as an advisory witness to the prosecution that you saw absolutely no reports that Mr. Bonnell had the ammo in his pocket on February 16th when he was collected from his residence.
That's correct.
And Mr. Bonnell was surprised, or let me ask you this, your review of the reports did not reflect any type of communication to Mr. Bonnell that he was made aware that law enforcement was going to be coming to his residence on February 16th, 2020.
Can you re-ask that?
Sure. Your review of the reports do not reflect that Mr. Bonnell was given a heads up that law enforcement was coming to his house on February 16th, 2020.
Correct.
And again, you testified a moment ago to this jury under oath that you, none of the reports that you reviewed indicated or documented the .22 caliber shell casings in Mr. Bonnell's pocket.
Beyond his statement, no.
But you did have an opportunity to review the nearly 6-hour interview with Mr. Bonnell at the Weld County Sheriff's Department on February 16, 2020.
Yes.
And Mr. Bonnell was interviewed at the Weld County Sheriff's Office, which is your home base, right?
Yes.
He was interviewed both by your colleague, Detective Mark Geyer,
Yes.
and he was interviewed by the Larimer County Detective or Investigator, Mr. Schell.
That's correct.
And within the first few minutes of, or first quarter of that interview, Detective Schell said, and I quote to Mr. Bonnell, "They told me when they first met you at your house, you had some .22 caliber shell casings in your pocket. Tell me, what's up with that? Why did you have those in your pocket?"
Correct. Like I said, other than his statements, there was nothing else.
But that wasn't his statement, that was Mr. Schell's statement, correct? And I can show you the transcript if you need, or we can watch the video.
No, I'm familiar with it. I
So that was
remember.
Mr. Schell's statement, not Mr. Bonnell's.
That's correct.
So Mr. Schell, as a member of law enforcement, had information from some unknown colleague that when they approached or got Mr. Bonnell from his residence, he had those casings in his pocket.
That was what he said to him.
That wasn't something Mr. Bonnell just made up.
Correct.
And even later in that interview, or let me ask you this, Mr. Bonnell acknowledged having those .22 casings in his pocket.
He did.
He didn't deny it.
Correct.
And even later on in the interview, that wasn't the first time law enforcement asked that of Mr. Bonnell.
I'm not familiar with that.
Sure, Mr. Schell later on said, "And you think the shell casings were just still in your pocket from last weekend?"
Yes, it was revisited with Mr. Bonnell.
And even Mr. Schell said, "My wife constantly complains that she finds bullets in my pockets, right? You know, because you go to the range or whatever."
That's correct.
And even later, Mr. Schell said, I'm confused because earlier I felt like you told me that the reason you had the .22 casings in your pocket is because a week ago you went out target shooting at your inaudible that you were building, right? We talked about that earlier."
Yes,
And again, Mr. Bonnell acknowledged having the casings in his pocket.
that's correct.
Mr. Schell later said, obviously you had empty brass in your pocket, so And Mr. Bonnell again acknowledged having the 22 casings in his pocket.
Yes, during the interview, multiple times he admitted to having ammunition or casings in his pocket.
And even later, that was a subject Mr. Geyer asked, or Detective Geyer, asked Mr. Bonnell.
Yes.
And despite knowing this information and law enforcement having this information, you did not direct any member of your agency to even take a photo of those casings in his pocket.
Wasn't aware of any casings that were in his pocket.
But your colleagues were, correct?
They were reported to have known about them through Mr. Bonnell and Mr. Shaw. However, there were no casings or bullets that were produced that I was aware of.
And that's because no one bothered to do that, correct?
I don't know how the casings and bullets came up as a topic.
But it was enough of a topic that 2 trained detectives spent 6 hours interviewing Mr. Bonnell about it.
Yes, they did interview him about the casings that were supposedly in his pocket.
And then got affirmations from him that he did have it.
That's correct.
And still, even after that point, no one bothered to even take a picture of him.
No pictures were taken because nothing was produced from it. There were no casings or bullets that I'm aware of from this case.
And that's again because no one did their job to do what they needed to do to collect that piece of evidence.
I disagree with that.
And you disagree with that because you're an advisory witness sitting here with the government, correct?
Objection, argument.
I'll take that back. And so you know the importance, and we've seen hundreds of pieces of evidence, correct?
Yes,
Everything from receipts
yes,
to cardboard boxes of Walmart, of phones that were purchased at Walmart.
yes,
Everything from cleaning supplies, baking soda, pictures of that.
yes.
And yet no one thought it was important to document ammunition found on the property owner of where a body was located.
It's because we're not aware of any bullets or casings that were produced from Troy Bonnell's pocket.
And you're saying we, but clearly Mr. Schall and Mr. Geyer were.
Mr. Shaw did introduce that to Mr. Bonnell.
Nothing further, thank you.
Any redirect?
No, Your Honor.
Any questions from the jury? Okay, thank you. You're welcome to step down. You're welcome to join the prosecution. And I'm assuming he's subject to recall for the defense?
Yes, and he
Thank
will be,
you.
thank you.
Thank you. Mr. Rudd?
Your Honor, if we could go back on Bluetooth.
Yes. Ms. Palmer's, her office is next door. She has a secured locker, and she's going to get an exhibit for a moment. She'll take about 2-3 minutes. Detective.
Your Honor, at this time, the people would invite Investigator Atwood forward and ask that he unseal on the record what has previously been admitted through Detective Aaron Horowitz as the fixed blade knife recovered from Mr. Eastman. Ask him to unseal that item and publish it to the jury at this time.
Thank you. So he's going to unseal it, and then Christina is going to publish it to you. She's going to go from left to right in front of the jury box so you can see it.
And then when he's done, we're going to reseal it.
Thank you. Need a scissor?
Not sure. Because on this desk, you
Yeah, wherever you're comfortable, yeah. Why don't you describe what you're doing while you're doing it?
do you want me to do it?
I think I think Cheryl can hear you.
Okay, I applied gloves to my hands. I am taking a pair of scissors from the court to break the seal.
And again, that's Exhibit 169.
Yes, that's the way we'll look.
And we'll give that to Christina. And we'll get her a pair of gloves also. I can please have all cell phones turned off in the courtroom.
This time, Your Honor, the people would invite Detective Atwood to place new evidence tape on People's Exhibit 169 and reseal it.
Thank you.
And again, describe for the record what he is doing.
This time I'm applying new gloves. I'm ensuring that the box is reconnected together. Now I'm applying new Member County Sheriff's Office red evidence tape. Now I'm going to initial the evidence seals with my initials, badge number, and date time.
Thank you. Mr. Wren?
Your Honor, at this time, the people rest their case.
Thank you. So what the prosecution is saying is that they're resting their case in chief. In every criminal case at this stage, when the prosecution rests their case in chief, I need to take care of some legal issues outside of your presence with the lawyers. This may line up with a good morning break. It may be longer than 15 minutes. We'll just kind of wait and see, but I would like you to maybe come back at, why don't we say 10:20? Just because the prosecution rested their case in chief doesn't mean that you can start talking about the case or doing any independent research. The admonition that I've been giving you regularly still applies. Let me give you that admonition. Until the trial is completed, it is not completed. You must not discuss this case with anybody. That if somebody approaches you and tries to discuss the trial with you, please let me know about it immediately. It's also important that you must not read or listen to any news reports of the trial. Do not in any way try to gain information about the case outside of this courtroom. Please don't do any independent research, and please do not form or express any opinion on the case until it's finally submitted to you. We'll see you back here. We'll try to get you in as close to 10:20 as possible, okay? Let's all please rise for the jury. Okay, you're welcome to be seated. Let's see, we're outside the presence of the jury. Is there any Rule 29 motions from the defense?
Yes, sir, may I have one moment, please?
Yes.
Thank you. Judge, at this time, the defense would move pursuant to Rule 29, subsection A, for a motion for a judgment of acquittal. The defense makes this motion, and of course, this court knows that the issue is whether the relevant elements, both direct and circumstantial, when viewed as a whole, in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charges beyond a reasonable doubt. In performing this function, the court is bound by the 5 well-established principles of law. I guess the first point I want to make is the court has heard substantial evidence regarding the death of Heather Christina Frank. However, the government has not charged in the complaint and information that Mr. Eastman was responsible for Heather Christina's death or tampering with the body. Instead, the complaint and information lists Heather Christine Frank, which is a different individual that the court has heard evidence on. So based on that, I don't believe the court can say that it has received any evidence, both relevant, direct or circumstantial, that even if viewed in the light most favorable to the prosecution, that would satisfy the motion for a judgment of acquittal. The Due Process Clause of the United States and the Colorado Constitution prohibits the criminal conviction of any person except on proof beyond a reasonable doubt. And at this time, we would ask the court to dismiss those counts based on that.
Anything else you want to say with regard to any of the other charges?
We would just rest on the record.
Thanks, Mr. Wren.
We would submit the issue to the court based on the totality of the evidence as it stands.
Thanks. So the court, pursuant to Rule 29A of the Rules of Criminal Procedure and pursuant to People v. Bennett, found at 515 P. Second 466, the Colorado Supreme Court case from 1973. There are dozens of cases subsequent to that case that stand for the proposition that to withstand a motion for judgment of acquittal, the prosecution has the burden of presenting evidence which, when viewed as a whole and in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable person the defendant is guilty of the crime beyond a reasonable doubt. The court has considered all of the evidence in this case, including eyewitnesses, the physical evidence in this case, the scientific evidence in this case, the digital evidence in this case, both the direct and circumstantial evidence in this case, the defendant's statements, both verbal and nonverbal. The court is going to find that there is ample evidence finding that the prosecution has met their burden, and the court is respectfully going to deny the motion for judgment of acquittal based on the totality of the evidence that I heard in this case.
Judge, should I just ask the court to, for the purposes of the appellate record, make a specific record on how Mr. Eastman would have been on notice and received due process if the complaint and information for 2 years has listed the person as Heather Christine Frank, and that has not been the person that we've heard any evidence about who is deceased in this case?
The court is going to find both direct and circumstantial evidence demonstrates ample evidence that Mr. Eastman was abundantly clear and put on notice of Ms. Frank's identity based on the voluminous discovery, the statements made by your own client as to who the victim was of the death that they were investigating. So there's ample evidence, and so the court finds that there's undoubtedly no question of who the prosecution alleged in the criminal information. There's zero prejudice to your client as to that issue. And so the court is finding that there's ample evidence to bind over these charges and let the jury make a determination whether the prosecution has met their burden. Mr. Eastman, I earlier today provided you with an advisement. In Colorado, we call it a Curtis advisement, and essentially it discusses your right to testify and not testify. Do you recall that advisement?
Yes, I do, Your Honor.
Would you like me to repeat that advisement? I'll be glad to do so.
No.
Ms. Devereaux, would you like me to repeat that advisement to your client?
No, sir, but we are going to reserve giving the court an answer on whether or not Mr. Eastman is going to elect to testify until after we've presented additional witnesses. And just for the record, I do just want to make sure I constitutionalize our motion for a judgment of acquittal under both the Colorado and United States constitutions. Thank
you. Anything else, Mr. Wren, you want to say about that?
No, Your Honor.
Okay, so when would you like me to ask you when your client is ready to answer the question whether he wants to testify or not?
Your Honor, we have witnesses scheduled for the remainder of today and on Monday, so we would ask the court to revisit this on Monday afternoon, please.
Okay. Okay, so let's take a break, and we'll get started up again at 10, maybe 10:20, 10:25, and then we'll proceed with witnesses, okay?
Thank you.
Thank you.
Have a good break, Kevin.
Thank you.
Please have the key to the room. see the cast report in the exhibits. Did you?
Should be.
I haven't seen it in the room. Oh, okay. I was just worried that it got thrown away.
Okay, why don't we go ahead and get started? Okay, we're back on the record. It's 10:29. We're here regarding People versus Kevin Eastman, 20 CR 461. We're outside the presence of the jury. And Ms. Morris, did you want to put something on the record that you briefly discussed with me, the presence of the prosecution during the break?
Yes, Your Honor. I just wanted to note that we were alerted by one of our witnesses that they saw someone with a lanyard in the courtyard area of the courthouse and asked where the courthouse was, and that was the extent of the conversation. I'm not sure if that was a juror in this case, but it was someone wearing a lanyard.
So what efforts can we make to avoid your witnesses potentially having contact with jurors, especially since jurors are wearing lanyards that say juror?
We have given them our witnesses an indication to avoid talking to any jurors, especially ones, or talk to anyone really, and we have moved them all to the second floor to keep them out of the immediate area where the jurors are likely to be.
Okay, thank you.
Specifically, Judge, they're in the larger juvenile waiting room that's kind of hidden behind the bathrooms and out of that front main lobby area of the second floor as well.
Thank you. Does the prosecution want to say anything about that issue?
No, Your Honor.
Any other issues?
Just to be clear for the record, we do have some that are in the locked rooms or the rooms that the jurors wouldn't have access to as well, but we've moved them out of the immediate area where the bench is, outside the jury room.
Okay, great, thank you. All right, let's bring the jurors in. Okay, welcome to be seated. See if the presence of the jury is now 10:32. We kind of keep you in the loop of what to expect for the rest of the day today. So we're going to hear from witnesses from the defense until about noon or so. We'll try to finish as close to noon as possible. We may go a few minutes before or after, depending on where we're at with that witness. We'll take our lunch break, and then we'll be hearing witnesses for the remainder of the day, okay? We're absolutely still on track with regard to the timing of the trial. And the defense may call their next witness.
The defense calls Justin Atwood.
And Detective, I'm going to just swear you in again. And you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth.
Yes, sir.
Thanks. Why don't you have a seat? Again, no need to introduce yourself to the jury, but for the record, if you could just state your name.
Sure, Justin Atwood, ATWOOD.
Thank you. You're welcome to examine.
Good morning.
Good morning. When we finished up the day on Wednesday, you were testifying about Mr. Eastman's purchase at Best Buy on February 15th of 2020. Do you recall that?
Yes, ma'am.
And at that time, you told the jury that Mr. Eastman had purchased 2 phones at Best Buy, correct?
Yes, I made an error in my testimony. It wasn't my intention to mislead anybody, but I did review my reports further.
And when you reviewed your reports further, you realized your error was that he only purchased 1 phone at that time, correct?
That is correct.
And so on February 21st, 2020, did you go to the Best Buy store?
I did.
And did you speak with any managers?
I believe I spoke with 3 managers.
Okay. And while at the store, did you review the video surveillance of the transaction on February 15th of 2020?
Yes, I did.
And did you also view the video surveillance of the subsequent return of the phone?
Yes, I did.
And did you obtain a copy of the video surveillance of both the original purchase and return of the phone?
I'm sorry.
Did you obtain a copy of the video surveillance footage of the original purchase as well as the return of the phone?
Yes, ma'am.
Was that provided to you by the store management?
Yes, it was.
And did you review the video again after you received it from the store management?
I did.
And after you reviewed it, did you log that into the Larimer County Sheriff's Office digital evidence folder as JMA 11?
I'm not entirely sure of the identifier, but yes, I did log it into evidence.
And that footage that you obtained or collected contained 2 clips, one for the purchase and one for the return, correct?
It's my understanding that there is 4 different videos on each file, if that makes sense.
Yes, so
Okay.
a better question is, there were 2 files that you collected,
Yes,
and each of those files contained 4 camera views of the time for which the video was collected.
yes.
And may I approach with what's been marked for identification purposes as defense triple I? I've already shown this to the prosecution.
Sure.
So do you recognize what's been identified for identification purposes as defense triple I?
Yes, this is the video that your investigator showed me earlier this morning.
And how do you recognize it?
It's identified with, it's a disc with Best Buy written across the top, and it has my initials, my badge number, and today's date on it.
And is this the Best Buy security video you obtained depicting the purchase and the return of the cell phone by Mr. Eastman on February 15th of 2020?
It's the video that I collected and logged into evidence, yes.
Right. And at this point, is this a fair and accurate depiction of that purchase and return?
Yes, ma'am.
Your Honor, at this time, I'd request to introduce Defense Exhibit Triple I and publish.
Any objection?
No.
Triple I is admitted. You're welcome to publish.
Thank you. Before we do that, I just want to be clear that the time period, the purchase of the phone was made at 12:29 p.m., is that correct?
I did not pay attention to that when I watched the video earlier. I might have to review my report to verify that.
Let's do it this way before we watch the videos.
Okay.
Did you get a receipt for the original transaction and return from the store management?
Yes, ma'am.
All right. Your Honor, may I approach with what's been marked for identification purposes as Defense Exhibit Triple H? I've already shown this to the prosecution.
Sure.
Do you recognize what I've handed you?
Yes, ma'am. It's the attachment to my supplement number 66.
Okay.
And it has the identifier of JMA 10. JMA 10, which is the copies of the Best Buy receipts for the original purchase and the original return. And it states that these are duplicate receipts.
And those are duplicate receipts or Xerox copy of the physical receipts that you obtained from store management at Best Buy, correct?
So these are copies of duplicate receipts that I got from the management. It's not the original receipts that were provided to who purchased the phones.
And are those, but they were provided to you from the store management
That is correct.
at your request?
Yes.
And those, that exhibit, defense, what's identified as defense exhibit triple I is a fair and accurate depiction of the receipts you obtained from the store management?
I'm sorry, that confused me.
Sorry.
I apologize.
It's okay. So what's contained in defense exhibit, triple H, I'm sorry, that I misspoke.
You said I. and
That's
I'm
why
sorry.
I confused you. So defense exhibit triple H, is that a fair and accurate depiction of the receipts that you obtained from the store management for these purchases?
Yes, ma'am, and it's based off of the fact that my handwriting's on it.
Okay, thank you. And at this time, I'd move to admit and publish defense exhibit triple H.
Any objection?
No, Your Honor.
Triple H is admitted.
Thank you. Your Honor, we also don't have the ability to put that up on the video. Could we quickly pass that around while I set up the other exhibit? Sure. Thank you.
Let's wait until they finish the actual paper.
Just making sure.
Okay.
Thank you. I'm sorry, were you waiting for me? Okay.
We're good. I think, have we finished publishing? Everybody finished with reading? No,
Oh, okay, sorry, I thought she was sitting down and I missed it.
You're welcome to publish the video.
And so for the record, this is Defense Exhibit III. And so Detective Atwood or Investigator Atwood, these are the 4 camera views you were talking about, correct?
Yes, ma'am.
All right, and so the cameras are labeled camera 1, 2, 3, and 4?
Can I stand up to? Of course. There's a glare from the light, sorry. Yes, ma'am, that's correct.
Okay, so I'm going to start by playing camera 3 for the record. And this is Mr. Eastman entering the store, correct?
It's hard to tell in that view, but I believe so.
And could you specifically got the surveillance video for the time that he was inside the store, correct?
Yes. And I think that's the only person that matches his description from the video.
Thank you. And now I'm going to switch to camera 1. And I skipped ahead a little bit just so we're respectful of the jurors' time. You'll have access to the whole exhibit. But Investigator Atwood, do you see Mr. Eastman at the checkout counter? Sorry, the glare is probably going to make that very difficult.
So camera 2 in the top right, I believe is the checkout camera?
That's the self-checkout. Do you see the electronics section there?
I'm sorry, I'm going to have to stand up to the glare.
That's okay. I may approach it.
Sure.
Just direct your attention to.
This one,
And is that the checkout section in the electronics area?
I know that it's a desk where they sell the cell phones.
Okay.
I'm not sure if it's a self-checkout.
And sorry, not self-checkout, it's just the checkout or register in the electronics section where they sell cell phones.
Okay. I'll agree with that. I don't know.
And I know this view is a little hard to tell, but is that consistent with the individual who we just saw walking into the store?
Yes, ma'am, please.
And I switched to camera 2 here, which is as someone is exiting the store. Is that accurate? Just the view.
I'm sorry, where the handicapped person is, or are you talking about where the camera?
Camera 2 is where, not the doors, but just in front of the doors.
As a side profile, yes.
Yes, thank you. I'm just going to skip ahead a little bit so that you can see. And stand up if you need to. Do you see Mr. Eastman in this view? And if so, can you describe where he is
Sure,
in the frame?
I'm sorry, I didn't mean to.
Sorry, if you could describe where he is in the frame, just for the record?
Yes, ma'am. So in this view, camera 2, I'm sorry, can you verify? Yes, on camera 2, in the bottom right-hand corner, just above what appears to be a white desk, the subject that was identified as purchasing the cell phones to me by Best Buy security staff, which appears to be Mr. Eastman, is walking towards the south, my knowledge based off of being in that Best Buy store numerous times, towards the western exit door.
And that's from the right side of the frame to the left side of the frame?
Yes, ma'am, that's correct.
And do you see anything in his hands?
In this view, no.
I will.
It appears in his right hand there is a white box with a black emblem, but I can't tell what that emblem is.
And you don't see anything in his left hand, correct? Would you like me to play it?
If you could for it. Well, it looks like he placed the box into both hands, but it doesn't look like there was anything in his left hand initially.
And just to be clear, you only saw one box in his hand, correct?
I can only see one box, yes.
And that's consistent with the receipt that you obtained for the purchase of a singular cell phone?
Yes, ma'am.
Nothing further, thank you.
Thanks. Eddie Cross.
Yes.
I may approach.
Sure.
Investigator Atwood, so if I'm understanding the receipt that was introduced correctly, the initial purchase at Best Buy was made at 12:29 p.m., is that correct?
That is correct.
And the return of that same item, or what appears to be that same item, was made at 15:24 hours, correct?
That is correct, sir.
And can you just do the conversion for those who don't operate in military time?
Yes, 1524 is 3:24 in the afternoon. And basically, the 24-hour clock period, noon is 1,200 hours. You normally add 2 to the 12 or 3 to the 12 to add to make the 1,400, 1,500, and so on, is how that conversion is.
So purchase was made at approximately 12:30, return was made at approximately 3:24, correct?
That is correct, sir.
And I don't know if you have the receipt in front of you, or if you remember, but we can get it if you don't. Do you recall the purchase price paid for that phone at Best Buy?
I do not have it in front of me. If I recall, it was $289.
Okay.
Can I verify that?
Sure.
May I approach you on
Sure.
a refresh recollection?
Sure.
I'm refreshed.
Okay, and what was the purchase price at Best Buy?
There was multiple items that appear to be purchased on the original transaction. The original purchase price for the cell phone was $189. And then there appears to be a Verizon card for $70. And with tax, it came out a total to $280.
Okay. And does it say what that Verizon card is? Is it a purchase of minutes?
It does not. It just says Verizon, $70, V19.
Okay. Did you subsequently, or also get a video of the purchase made in the receipt that we've heard testimony about this morning at Walmart at 14:30 hours?
Did I get video for that purchase?
Yes.
I did not.
Okay. You said that originally you made a mistake as to whether or not 2 phones were purchased at Best Buy. What was the source of that confusion or mistake on your behalf?
Based on my personal knowledge of the case report, speaking with lab personnel who received the original Walmart receipt, my conversations with them, I placed both phones in my head as being purchased at Best Buy, and I inaccurately testified to that.
All right. So it turns out there appeared to be 2 receipts, one at Best Buy and one at Walmart on that date, correct?
That is correct.
One of the phones, the Best Buy phone, was returned.
That is correct.
No further questions.
Need redirect on those limited issues?
No, Your Honor.
Any questions from the jury? Okay, thank you. Welcome to step down and join the prosecution. Next witness, please.
Your Honor, at this time we call Jennifer Fick.
Good morning.
Good morning.
Do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth?
I do.
Thanks. Once you have a seat, make yourself comfortable. Feel free to adjust that microphone. Once you're settled in, if I can please have you introduce yourself to this jury by stating your name and spelling your last name.
Sure, Jennifer Fick, F-I-C-K.
Thank you. You're welcome to examine.
Thank you. Good morning, Ms. Fick.
Good morning.
Ms. Fick, where are you currently employed?
I'm currently employed with the Weld County District Attorney's Office as an investigator.
And before joining the Weld County District Attorney's Office, were you employed by the Weld County Sheriff's Office?
I was employed with the Weld County Sheriff's Office for 17 years prior to the DA's office.
And does that 17 years include in February of 2020?
Yes, it does.
And in February of 2020, what capacity was your employment at the Weld County Sheriff's Office?
I was a detective with the investigations unit.
And as a detective with the Weld County Sheriff's Office investigative unit, were you assigned to the case concerning the deaths of Scott Sessions and Heather Frank?
I was assisting in the homicide investigation, yes.
And did that include responding to the residents of 26-7-112 County Road 45?
Yes.
And do you know who the property owner of that residence is?
Troy Bonnell.
Did you go to the property alone that day?
I initially was called out there and contacted Lerner County deputies who were already on scene. And then after that, my team helped join, but I did respond by myself initially.
And did you go on February 20th, 2020 with Detective Geyer and Deputy Johnson to meet with Mr. Bonnell?
I did.
And did you go to Mr. Bonnell's property with Mr. Geyer and Mr. Johnson at Mr. Bonnell's request?
Yes.
Did you know why you were going to the property at Mr. Bonnell's request?
I was informed that Mr. Bonnell had contacted Detective Porter that there were some items of evidence that were left behind that he thought would be important to the case.
And when you arrived at Mr. Bonnell's residence, were you pointed out those items of evidence?
Yes.
What were they?
It was a journal of Kevin Eastman that was on the kitchen counter.
Okay. And along with the journal, was there also a planner?
Yes.
Okay. And within the planner, were you able to locate a receipt?
There were a couple of receipts, yes.
Was there a Walmart receipt?
Yes.
Do you recall what the date of that Walmart receipt was?
I believe it was February 15th of 2020.
Do you recall the time?
I don't.
Would it refresh your memory to review your report?
Yes.
Mr. Monroe, could you tell me which report you're referring to, please?
I'm on it. It is going to be supplement 48, specifically date stamp 11/32.
Thank you.
May I approach the witness?
Yes.
We have it nicely tabbed for you, so let me know when your memory is refreshed, okay? Is your memory refreshed?
Yes, it is.
What time was the purchase made on that receipt from Walmart?
3:04 p.m.
And do you recall what items were purchased?
I believe it was a flannel. I don't remember the specifics. I just remember there was a flannel that was purchased.
Would it refresh your memory?
Sure.
Same thing, you know? I'm going to ask you about all items, so you wanna. Is your memory refreshed again?
Yes.
Okay. So what items were purchased on that February 15th, 2020 purchase from Walmart?
So there are 4 items. The flannel, as I previously mentioned, 5 packs of t-shirts, socks, and then there was another item that didn't specifically say what the item was. It just had a bunch of letters.
Does it sound correct that a pocket tee was purchased?
Yes.
Men's socks,
Yes.
5-pack of boxer briefs,
Yes.
and the flannel?
Yes.
Let's talk about what was not purchased on that receipt, okay? Did you see that any pants were purchased?
No.
Did you see that any shoes were purchased?
Not on that receipt. No.
Did you see that any cleaning supplies were purchased?
No.
As part of your role as a detective at the time with the Weld County Sheriff's Office regarding the investigation of this case, did you make a series of phone calls relating to this investigation on February 25th, 2020?
Yes.
At some point during your work, did you learn of an associate of Mr. Bonnell's named Mario Romero?
Yes, I did.
Did you attempt to contact Mr. Romero regarding this investigation?
Yes, Detective Ong and I went to his last known location in Lock Buoy to try and contact him.
Were you able to contact him at his last known location?
Not at that time.
Did you leave a business card?
I did.
Did you eventually speak to Mr. Romero?
Yes, Mr. Romero did give me a call shortly after I arrived at his residence.
And when Mr. Romero called you back, is it fair to say that he called you back fairly quickly?
Yes, he did.
And at this point in the investigation, you and other members of law enforcement were looking into witnesses who had further information.
That's correct.
Objection, leading.
I will ask, were you and other members of law enforcement looking into for witnesses who had further information?
Yes.
Did Mr. Romero have much information for you regarding Mr. Eastman?
Objection, Judge. Calls for hearsay.
Not yet, but it may. The next question may be hearsay. So you want to ask that question?
Mr. Romero, I had asked him if he knew Kevin Eastman.
Wait. So.
Without saying what he did or he told you, just generally, did he have any information to provide you about Mr. Eastman?
No.
Did Mr. Romero instead have information regarding Mr. Bonnell?
Yes.
And again, at this point in the investigation, you were aware that Miss Heather Frank's deceased body was located on Mr. Bonnell's property.
That's correct.
And you knew did you know as well that Mr. Bonnell had been interviewed by law enforcement?
Objection, Judge Leading.
Let's do non-leading questions for your witness.
My question was, did you know whether Mr. Bonnell had been interviewed by law enforcement?
Yes.
Did Mr. Romero indicate whether he had reached out to Mr. Bonnell before contacting you?
Yes.
And does Mr. Romero indicate whether or not he actually spoke to Mr. Bonnell?
No.
Objection,
Wait.
hearsay.
So please don't elicit a hearsay response to the question. So the jury's not to consider that last response. Next question.
At some point, did you, in speaking with Mr. Romero, learn of a different phone number for Mr. Bonnell?
Objection, hearsay.
Not yet, it may, but you can answer that question. The next question may be hearsay.
Yes.
And as an a detective with the Weld County Sheriff's Office, were you aware of whether or not law enforcement already knew of Mr. Bonnell's phone number or a phone number for Mr. Bonnell?
We did have Mr. Bonnell's phone number that we were in contact with him.
And when the phone number that Mr. Romero provided you, was that different?
Yes.
Objection, hearsay.
Sustained.
Its effect on the listener lays the foundation for my next question.
So did that information assist you in doing any follow-up investigation?
I did do a follow-up from that.
Based on that information?
Yes.
So the court's going to overrule the objection based on the fact on listener.
Okay. Can you answer the question, please?
Yes, there was an additional phone number that I followed up on.
Okay. And when you say you followed up with that, can you please explain what you mean?
There's law enforcement databases that we can use to try and locate who owns or belongs to that number. And so I used a law enforcement database based on that new phone number that was given to me by Mr. Romero, and I couldn't locate an owner.
And do you recall what that phone number was?
I don't.
Would it refresh your memory to review your report?
Yes.
And let me ask you this. Did you do that research into the law enforcement database in part because it was a new phone number?
Correct.
Did you also do that research into the database of this phone number because you learned information from Mr. Romero that he was under the impression this was a secure phone number from Mr. Bonnell?
Objection, Judge. That is hearsay.
It is hearsay, so let's move on.
May I approach the witness regarding the refreshing her recollection for the phone number?
And what's the purpose of refreshing her memory if she's already told us that she used that number to do follow-up investigation? Is that phone number now being offered for the truth of the matter asserted?
I'll rephrase that then. Do you recall what the phone number was that you searched in the database?
No.
And I'm going to object again, Judge. That would be hearsay, the actual phone number.
So I'm not sure what the next question is going to be, but she's already indicated she used that phone number to do follow-up investigation. She came up empty, so what's the purpose of her
I'll move
letting
on.
us know?
Did you document that in your report?
Yes.
Thank you. Did you apply for a search warrant for that phone number to get those phone records?
No.
Did you submit a preservation of records request for that phone number?
No.
Did you ever obtain something called RTT data or location data from Verizon or any other carrier regarding that phone number?
No.
And as a detective with the Weld County Sheriff's Office, were you able to apply for a search warrant?
I didn't have any information to put into a search warrant because I didn't know who the owner was.
So my question was, in general, are you able or were you able in that capacity to apply for a search warrant?
I didn't, but I guess it would be possible.
You applied for, or did you apply for a search
did
warrant? No, let me finish the questions. Did you apply for search warrants as a detective in general with the Weld County Sheriff's Office?
Yes, many times.
Now let's move on to March 2nd, 2020. Did you interview an Anna Myers?
I did.
And did you interview Anna Myers regarding a nail appointment she had with Heather Frank on February 11th?
I did. She had reached out on a crime tip, and that's why I followed up with her.
Okay. And your follow-up was on the March 2nd, 2020 date?
Correct.
Thank you. And let's talk about that, or let me ask you this. Did you discuss how Ms. Frank appeared at that February 11th appointment with her?
Yes.
And do you recall Ms. Anna Myers telling you anything about Ms. Frank indicating that she didn't want to make another appointment that late again?
Yes.
Do you recall specifically that Ms. Frank had told her, remind me to not make another late appointment again because this is too late?
Yes.
And do you recall Ms. Anna Myers telling you that this was something that Heather Frank had told her on previous occasions?
Can you clarify your question?
Sure. Do you recall whether Anna Myers told you that Ms. Frank had indicated on previous occasions that she didn't want to make a late appointment again?
I don't remember. I believe that the only time she said that was the February appointment.
Moment, please. And your conversation with Ms. Myers was recorded, correct?
That's correct. Audio recorded.
And your testimony today is that you were not told by Ms. Myers that Ms. Frank had told her on previous occasions to not make late appointments again because it's too late and she has to get up at 3 a.m.
Judge, I'm going to object as to the characterization of her saying that wasn't what she was told. Investigator Fick specifically stated she didn't remember that portion of the interview. So that's really mischaracterizing what she said.
You could try to refresh your memory regarding
Would it
that.
refresh your recollection to view a transcript of your phone conversation with Ms. Myers?
I can review it. Sure.
So remember your refresh?
Yes.
So Ms. Myers told you on March 2nd, 2020, that Ms. Frank had said, remind me not to make a late appointment again because this is too late.
Yes, she did tell her that.
Ms. Myers also told you that Ms. Frank had said that to her before.
Yes.
And another topic of conversation that came up when you were speaking with Ms. Myers was how Ms. Frank appeared on that February 11th nail appointment, correct?
Yes.
And Ms. Myers did not tell you that Ms. Frank appeared very anxious.
No.
Ms. Myers did not tell you that Ms. Frank appeared unsettled.
No.
Did Ms. Myers only tell you that Ms. Frank seemed tired?
Yes.
Did Ms. Myers tell you that on that February 11th, 2020 nail appointment, Ms. Frank didn't seem any different other than tired?
Correct.
Okay, could I have a moment, please?
Sure.
Nothing further, thank you.
Thank you. Ms. Guthrie, any cross?
Yes, briefly. Good morning, Investigator Fick.
Good morning.
I want to first talk to you about the journal that you had picked up, and counsel showed you a receipt from Walmart that was located within that journal.
Correct.
First of all, did you established during your review of that journal that it was actually the defendant's journal, right?
Yes.
And you established that because what you did is you opened that planner up, and on the inside of the planner, there was temporary assignment information. There was loose papers. The defendant's name was on it. The defendant's phone number was on it, right?
That's correct.
And
I have
additionally,
a compound question, that was very unclear.
Why don't you break it down just a little
Sure.
bit about our answer?
so the defendant had his phone number in it, correct?
Yes.
The defendant had his name in it, correct?
Yes.
The defendant had in there a timesheet from Rifle Works,
Yes, written down, yes.
and that was located at 124 East 4th Street, Rifle, Colorado 81650.
Yes.
Objection, hearsay.
Overruled. It's-
And,
These are alleged statements made by the defendant in the journal,
correct?
so I'll overrule the objection.
Again, I would object, I think that this actual address was not something that Mr. Eastman wrote, I think it's coming from a receipt, is my understanding of the question.
Is that what you're referring to? Or
I'm
these-
referring to the inside cover, there were notes and loose paper that you took photographs of. Is that correct?
Yes.
So are these written notes in a journal, or are these like receipts or other documents inside a journal?
There was, it was another
I guess
document.
I'm asking the witness.
Both, written, and I believe the address was on a piece of paper that was folded up in the journal that had the address at the top.
And so let's be clear when you ask her questions about what's in the journal, whether it's things written in the journal or other documents that are included in the journal.
Sure. So the, on the first page, was his name written?
Yes.
Was his phone number written?
Yes.
And then inside the cover, there were notes and loose papers.
Correct.
One of those loose papers was something that was entitled temporary assignment information.
Yes.
And it was,
Objection, hearsay.
Ms. Guthrie?
it's located within his journal with his information on it.
That's not his statement.
Yes, also state the objection.
I want to talk to you about the information related to a phone number that was given to you by Mario Romero. And you were questioned about the fact that there wasn't a search warrant that was applied for that specific phone number.
Correct.
Can you tell the jury why that wasn't done?
There was no, what we call nexus, there wasn't enough information.
Objection. This calls for a legal conclusion.
This is explaining why she didn't personally apply for production of records or a search warrant. So she's welcome to answer the question.
Like I was explaining, the nexus, there has to be enough information for us to obtain a warrant to write, to have a judge sign it, for that company, phone company, to actually acknowledge and give us that information. So when I did the research, it came up as no, the number wasn't recognized, so I didn't have any information to follow up from there.
Thank you. I have no further questions.
Any redirect?
Yes, please. May I have a moment?
Yes.
You just testified that the reason why you did not get the search warrant was because you didn't have a nexus between that phone number and criminal activity, correct?
Yeah, not enough information.
Not enough information. But you, when you talked to Mr. Romero, you learned that before he...
Objection, hearsay, Judge, and leading.
I didn't even finish my question yet, and also she just opened the door because... Do we have a Bluetooth?
No, I'm finding that you can certainly ask her questions, but if it has anything to do with Mr. Romero telling her things in support of why she did or did not get a search warrant, it's hearsay, so I'm sustaining the objection.
Can we have a Bluetooth conversation, please?
Sure.
Nothing further, thank you.
Any questions from the jury? Thank you, investigator. We appreciate your time. You're welcome
Thank you.
to step down. Is she be excused from her subpoena, Ms.
No.
Devereaux?
No,
Okay,
we're gonna keep under subject.
thank you. Next witness, please.
Your Honor, at this time, we would call Scott Theis.
Thank you. Good morning. Sir, if I can please have you come on up to the witness stand over here. And then before you sit down, I'm going to swear you in as a witness. Is that okay?
Yes.
So you please raise your right hand. And do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth? Thank you. Why don't you have a seat, make yourself comfortable. You're welcome to adjust that microphone. And once you're settled in, if I can please have you introduce yourself to the jury by stating your name and spelling your last name.
My name is Scott Theis, last name is spelled Theis.
Thank you. Is it okay if the lawyers ask you some questions?
Yes.
Okay, you're welcome to examine.
Good morning, sir. Where do you currently live?
In Albany, Minnesota.
Okay. Were you living in an apartment with the address of 2162 35th Avenue Court in Greeley, Colorado, back in February of 2020?
Yes.
Do you recall what unit you lived in?
Unit number 1.
Was number 1 next door to number 2?
Correct.
Did number 1 share a wall with unit 2?
Yes.
Do you recall a day back in February 2020 when you were contacted by members of the Larimer County Sheriff's Office at your residence?
Yes.
At the time you were contacted by members of the Larimer County Sheriff's Office, had you resided in that unit for very long?
Not very long at all.
How long did you reside
I
there?
moved in there February 2nd.
February 2nd?
Yes.
And do you recall ever having an opportunity to meet your neighbor in Unit 2?
I met her twice.
And you said her was the neighbor female?
Yes.
And did you ever also meet a male in that residence?
Yes.
How many times did you have an opportunity to meet that male?
Once.
Can you generally tell this jury or explain what kind of neighbors the people in Unit 2 were?
They were pretty much neighbors. I mean, I didn't live there very long, but they were just neighbors, and so that was quiet most of the time.
And that was going to be my next question. Do you recall if they were very loud neighbors or very quiet neighbors?
Just quiet, I'd say.
Okay. Did you recall any kind of, or would it be normal to hear loud music coming from them?
No.
Would it be normal to hear loud banging or thrashing? I think we've all had those types of neighbors that drive us crazy.
Yeah. Every once in a while there'd be banging on the wall, but I'm not even sure if it was coming from them or one of the other neighbors.
Okay.
It wasn't frequent or nothing like that. It wasn't frequent.
Can you pull the microphone closer to you? The chair doesn't move, but the microphone does. There you go. Thank you, sir.
Sorry.
That's okay. So I want to take you back to that day when you were contacted by the members of the Larimer County Sheriff's Office, okay?
Okay.
Do you recall if you had been home at your residence prior to the on the Saturday prior to that?
No, I don't recall.
Okay. Do you recall the Larimer County Sheriff's Office Officer Rita Servine coming to speak with you, a female officer?
Yes.
Okay. Do you recall her asking you if you were home on Saturday at 5:30?
No, I don't recall that.
Okay. Would it refresh your recollection to listen to a portion of your an audio of that interview?
Sure.
You have a moment, please?
Sure.
approach?
Sure.
The question was 5:30.
Got some microphones for you, sir.
All right,
Something when you're ready, I'll press play.
okay.
Do you remember your refresh now?
Yes,
So do you recall now telling Mr. Dean, or Investigator Devine, that you were home at your residence around 5:30 on the previous Saturday?
yes,
And when you were home on that previous Saturday, did you hear anything coming from your neighbor's residence in Unit 2?
not that I recall.
Did you hear any type of screaming?
No,
Did you hear anything that would be consistent with fighting?
no,
Did you hear anything that would be consistent with someone struggling with someone else?
no,
Do you remember hearing just general noises that, or thumps that would be consistent with everyday life?
yeah,
Do you recall what apartment that came from?
I think number 2.
Okay. Were those noises, well, let me ask you this, do you recall telling Investigator Servine that you could not tell what apartment it was from?
Yes,
At any point, did you hear anyone, did you call for the police?
no,
Did you hear anything that gave you cause for concern?
no,
Nothing further, thank you, sir.
all right.
Thank you. Any cross?
Yes. Good afternoon, sir.
Hello,
Do you recall what you were doing on Saturday, February 8th at 4:30?
no, I do not.
And when I say 4:30, I'm talking about in the afternoon.
Yeah,
You don't remember what you were doing?
no,
You said at 4:30?
Yes.
Okay.
Okay. Do you remember what you were doing at 5:30?
no,
Now, I want to ask you about 6:30. Do you remember if you were home at that time?
no, I do not.
Is it fair to say that as you sit here today, you don't remember that day much at all?
Exactly.
No further questions.
Thank you. Any redirect?
No, sir, thank you.
Any questions from the jury? Thank you. We appreciate your time. You're welcome to step down. Can he be excused from his subpoena?
Yes, thank you.
Thank you. Appreciate your time. Next witness, please.
Your Honor, we would call Deputy Aaron Hawks.
Approximately how long do you think his direct is going to be?
Very short.
Okay. Morning. Before you sit down, I'm going to have you raise your right hand and swear you in. Do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth? Thanks. Why don't you have a seat and make yourself comfortable? Feel free to adjust that microphone, and once you're settled in, if I can please have you state your name and spell your last name.
Aaron Hawks, Hawks.
Give me 1 second, please. How do you spell your first name?
Aaron, Aaron.
Thank you. Welcome to examine.
Thank you. Good morning.
Morning.
Sir, how are you currently employed?
I work for the Laramie County Sheriff's Office as a patrol deputy
Okay, and how long have you been employed at the Laramie County Sheriff's Office?
since 2011.
And did you have any prior law enforcement experience before you began at the Sheriff's Office?
I did not.
At some point, did you become involved in the investigation into the death of Scott Sessions?
I did.
And how were you alerted or tasked to take part in the investigation?
We responded out. I was a part of the Strategic Enforcement Unit at the time, which was a handle in Investigations Division. We were notified that a body was found in the mountainous area of Laramie County.
Okay. Did you participate in the search of Heather Frank's residence at 2162 35th Avenue, Court Number 2?
I was present. I wouldn't say that I partook in the search and processing, no.
Did you participate in searching a dumpster outside of the residence?
I did.
Can you describe where that dumpster was located?
It was maybe, the apartment unit as it sits, it would be on a curb line, maybe 20 yards or so from the threshold to the residence in a communal area and in the courtyard, kind of.
Okay, and you said it was in a communal area. Did it appear the dumpster was specific to her residence or something that any residence?
No, it looked like it would have been for the complex.
Okay, and before I forget to ask you, what day was the search of the dumpster?
I would have to look back. It was a few days after the initial report, of course.
Would it refresh your recollection to take a look at your report?
Yes, if I may.
Supplement 10.
Thank you. So to answer your question, it would have been Sunday, February 16th.
Thank you. And what were you looking for in the dumpster?
Nothing of particular note, anything that may be tied to that residence.
Okay, were you looking for items that could potentially contain evidence relating to Mr. Sessions' death?
Yes.
And did you locate any trash in the dumpster that you identified as coming from Ms. Frank's residence?
Yes. Yes.
How were you able to identify it as coming from her residence?
It was a trash bag that was similar to the style that had been located in the residence, and there was, I think, mail that had Heather Frank's name on it in the bag.
Okay. Did you collect that bag into evidence?
I turned it over to a CSI, Mr. Gillum, to be checked into evidence.
Was that the only trash bag that you identified or had other officers collect from the dumpster?
That I can recall, yes, ma'am.
And did you locate any other trash bags that you believed were possibly from Ms. Frank's residence?
Not that I know of, ma'am.
Did you locate any items of note other than that trash bag in the dumpster?
No, ma'am.
Did you locate any items containing blood in the dumpster?
Not to my knowledge, no, ma'am.
Did you locate any weapons in the dumpster?
No, ma'am, I did not.
Nothing further, thank you.
Thanks, Cindy Cross.
Yes. Morning, Deputy.
Good morning.
You wrote in your report regarding the search of the dumpster that you located one trash bag in the dumpster, is that correct?
One that was recognizable as being from their apartment. There may have been multiple items of trash in the dumpster.
All right. And that search was being conducted almost a week after Scott Sessions' body had been located up in Pingree Park, correct?
Yes, roughly 6 days from his body being found.
Do you know when the trash is collected from that dumpster by the trash company?
I don't.
Okay. No further questions.
Thanks. Any redirect?
No, Your Honor.
Any questions from the jury? Thank you. You're welcome to step down. We appreciate your time.
Thank you.
May he be excused from his subpoena? Ms. Morris?
Yes.
Thank you. Appreciate your time. Can the parties go on Bluetooth real quick? Trying to figure out whether we should take an earlier lunch or start with another witness. Mia. We have a pretty quick witness, so we're going to handle her testimony, and then we're going to take our noon break. You want to call your next, or recall the next witness?
Your Honor, the defense at this time is going to recall Sierra Vessels. I believe it's Sierra Vessels Martinez now.
Yes. Hello again. If I can please have you take the witness stand. Given the lapse of time, I'm going to swear you in again, okay? And do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth?
I do.
Thanks. Why don't you have a seat, make yourself comfortable. And while you don't have to introduce yourself to the jury again, why don't you just state your name for the record?
My name at the time of this investigation was Sierra Vessels. It's currently Sierra Martinez.
Thank you. You're welcome to examine.
Congratulations, I suppose that means.
Thank you.
So when we heard from you last time, when the government called you, you indicated that you, I believe I asked you this, you did the search warrant of the chicken coop found on Mr. Bonnell's property, correct?
Correct.
Did you find any chickens in the chicken coop?
No.
Did you find any chickens on Mr. Bonnell's property at all?
No.
Did you find any type of signs or indication that there had been recently chickens on the Bonnell property?
No.
Your Honor, I'm going to show this witness what the government has already admitted to evidence as People's Trial Exhibit 176, specifically page 21.
Okay.
Ms. Vessels, I'm showing you what's been marked as People's Exhibit 176. And on page 21, I'm showing you it's a phone number labeled 303-507-8005, correct?
Correct.
And this exhibit indicates that calls from this phone number ending in 8324, one outgoing was made to that 303 phone number at 3:15 on February 11th, correct?
Correct.
And then again at 3:16 p.m. there was an incoming call from that 303 number.
Correct.
To the phone number ending in 8324.
Yes.
And this exhibit also indicates or tells us that the 8324 number was identified as Mr. Bonnell's, correct?
Correct.
And that Mr. Bonnell's phone number ending in 8324 was a Verizon phone number.
Yes.
As part of your role in helping the Weld County Sheriff's Office investigating this case, did you have an opportunity to search through Verizon records for Mr. Troy Bonnell?
Yes, I did.
And can you explain to the jury what that process looked like for you?
Yeah, so I created an Excel spreadsheet and I pulled out each phone number and then I worked to identify who that phone number was connected to using law enforcement databases.
And one of those phone numbers you worked on identifying, was that the 303-507-8005 phone number?
Yes, it was.
And were you able to identify who that phone number belonged to at the time?
Yes.
Objection, hearsay.
Overruled.
You were?
Yes.
Can you please tell the jury who that phone number belonged to?
Mr. Stylick?
Does John D. Stylick sound familiar?
Yes.
Does the date of birth 4/16/66 sound familiar?
Yes, it does.
At this time, Your Honor, I would ask the court to take judicial notice of two different
Your
things.
Honor, I'm going to ask that we go Bluetooth on this.
Okay.
Okay, so we, again, just to make sure we're all on the same page, you looked into who the owner of the 303-507-8005 phone number was.
Yes,
As we saw, Mr. Bonnell made incoming and outgoing calls to that phone number on February 11th, correct?
yes,
And that was at 3:15 and 3:16 p.m.
yes,
And those phone call, or that phone number, 303-507-8005 for John D. Stylek, and Mr. Stylek is a licensed lawyer in the state of Colorado.
I did not know that at that time, but I have since learned that, yes.
Nothing further, thank you.
Any cross?
You don't know if Mr. Stylek is Mr. Bonnell's divorce attorney, correct?
Correct,
You don't know if he represents him in business transactions?
correct,
You don't know if he represents him in contracts engaged in by his Bonnell Field Services LLC?
correct.
And you have no idea what was discussed between those two on February 11th?
Yes, I had no idea what the content of the conversation was.
All right, no further questions.
Thanks. Any redirect?
Yes, briefly. Is it also fair to say that you do not know whether or not Mr. Bonnell contacted Mr. Stylek out of concerns about his actions in this case?
Yes, I have no idea why he contacted Mr.
Nothing further, thank you.
Any recross?
No.
Any questions from the jury? Okay, thank you. You want to step down? We appreciate your time. May she be excused from her subpoena?
Yes, thank you.
Thank you. Okay, we're going to take our noon break. I would like to get started up again at 1:15 since it's now 11:56. Hopefully that will give you enough time. I want to again remind you that you may not discuss this case with anybody. That includes your family, people involved in the trial, other jurors, witnesses, or anybody else. It's real important that I think everybody has been compliant with this, but keep your lanyard on. That way you can let people know that you're a juror, because there may be witnesses that are coming in who may not know who you are, and you may accidentally talk to them. And so please keep that lanyard on so you're identified as a juror in this case. If somebody does approach you and tries to discuss the trial with you, let me know about it immediately. It's also important that you must not read or listen to any news reports of the trial. Do not in any way try to gain information about the case outside of the courtroom. That includes no research on the internet, medical or law books, or dictionaries. Finally, it's especially important that you not form or express any opinion on the case until it's finally submitted to you. Have a great lunch. We'll see you at 1:15. Let's all please rise for the jury. You're welcome to be seated. And I should have asked, is your next witness available at 1:15?
Yes.
Great, okay. We'll see you then. Have a nice lunch.
You too, sir.
If you want to give me your Bluetooth, we can recharge them during that break.
No, I just want to make sure it goes over there before I go through here. Thank you, yeah. Have a good lunch, buddy.
Thank you.
jurors in?
There you are.
No, you're on.
Okay, let's bring the jurors in.
Need this stuff.
Policy to start where they had to hand them out, and then everybody stopped. Like, at the beginning, they all did it, and then over time, most of them just stopped doing it. And there's a few,
weird.
there's a few stragglers that.
Yeah, definitely seemed more old school. Customer service is important to the Colorado Bureau of Investigations. Certainly. Barring. Get the differential from multiple colors and paper, right?
You're welcome to be seated. Hope you had a good lunch hour. And you're welcome to call your next witness, Ms. Devereaux.
Your Honor, the defense calls Jessica Rader.
Thank you. Good afternoon. Before you sit down, I'm going to swear you in as a witness. And do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth? Thanks. Why don't you have a seat, make yourself comfortable. Feel free to adjust that microphone. And why don't you go ahead and introduce yourself to the jury by stating your name and spelling your last name.
Jessica Rader, Jessica-Rader.
Thank you. You're welcome to examine.
Ms. Rader, how are you employed and what is your official title?
I'm employed with the Loveland Police Department, and I've been assigned to the Northern Colorado Regional Forensics Laboratory as a forensic scientist specializing in latent prints.
Could you briefly tell the court and the jury what your duties are as a latent print examiner?
I receive, process, and analyze items of evidence for the presence of latent prints. I'll conduct comparisons if necessary, and then issue reports with my findings.
And how long have you worked in the latent print field?
I've been working in the latent print field since April of 2013. I began my career as a latent print technician, working for a government contractor known as Oak Ridge Associated Universities. And after that, I started working for the Loveland Police Department as a forensic scientist in September of 2014.
And what kind of education and training did you receive in order for you to do your job and qualified to do your job?
I earned a Bachelor of Science degree in forensics biology with minors in chemistry and biology from Virginia Commonwealth University in 2011. When I began working for the Loveland Police Department, I had to successfully complete a training program with the Colorado Bureau of Investigations, and I successfully completed that in March of 2016. And since that time, I also have over 375 hours of additional training related specifically to latent prints.
And are you a member of any professional organizations related to your work?
Yes, I am a member of the International Association for Identification, also known as the IAI. It's essentially the world's largest and oldest body of professional forensic scientists that provide guidance and training to its members. I'm also a board member for the Rocky Mountain Division of the IAI, which encompasses the states of Colorado, New Mexico, and Wyoming.
And are you a certified latent print examiner?
Yes.
And what are the requirements to be certified?
To be certified, you have to first meet a certain set of requirements. Usually that consists of the number of training hours that you have had and also years of experience. Once you've met that requirement, you're eligible for the test. The test is an 8-hour exam that consists of a written portion and a comparison portion.
And once you've completely finished that and you successfully passed it, you have a testimony evaluation section as well. And I did complete all of those.
Is the lab that you work in, is it accredited?
Yes.
And who are you accredited through?
We're accredited through the American National Standards Institute National Accreditation Board.
And is the work that you do reviewed for accuracy?
Yes.
How is that? Could you please explain that for the jury?
So the latent unit has a multiple review process, if you will, and that ensures quality to our system. One of the reviews we have is known as a suitability review. After the original scientist on a case has reviewed all items, a second qualified latent examiner will review them to ensure that no latents of value or latents that were considered not of value were overlooked. Following that review, we also perform 100% verification. So anytime we come to a conclusion when we conduct a comparison, another qualified latent examiner has to verify that conclusion. And we also do 100% technical reviews. This is where we're looking for making sure we don't have any spelling errors or any resources are missing from our case file. And then from there, there's also randomly assigned administrative reviews.
And have you been previously qualified and have you testified as an expert in latent print examination?
Yes.
How many times?
Approximately 12 times in the Weld, Jefferson, and Larimer County courts.
At this time, Your Honor, I would offer Ms. Rader as an expert in the field of latent print analysis.
Mr. Wren? Ms. Guthrie?
No objection, Judge.
Thank you. So the court's going to find that Ms. Rader, based on her knowledge, skill, experience, training, and education, is an expert in the field of latent print analysis and may offer an expert opinion with regard to that subject matter pursuant to Rule 702 of the Rules of Evidence. You're welcome to continue.
Thank you. Could you please tell the jury what friction-ridged skin is and where it can be found?
So friction-ridged skin can be found on the palms of your hands, fingers, toes, and soles of your feet. And it's different from other skin on your body in that it's rough and not smooth. So if you feel the backside of your hand, you'll notice that skin's smooth, whereas the inside is rough. And this roughness is due to the friction-ridged skin having what are called ridges and furrows. And I always like to think of ridges and furrows as though you're looking at a plowed field. Like those raised piles of dirt are the ridges, and those spaces in between are the furrows. And as latent examiners, we actually care about those ridges because they flow along your friction-ridged skin in a unique arrangement that we can then use for comparison purposes.
And what is a fingerprint?
A fingerprint is an impression of your friction-ridged skin from the end joint of the finger.
Okay. And what is a known standard?
So when we have an unknown impression, we need something to compare it to, and that's considered a known standard. A known standard is an intentional recording of your friction-ridged skin for the purpose of comparison. And typically that's in the form of either a 10-print record or a palm print record. And they can be captured one of two ways. You can have them captured using ink and cardstock paper or electronically using live scan devices. And so, for instance, if I had an unknown latent fingerprint, I would want to compare that to a 10-print record. And what that consists of is they take all 10 of your fingers and they'll roll each one in its corresponding box on the form. So if it's your right thumb, they'll roll it into the ink from one side to the other and then place it into the right thumb box on the form. And so they do that for all 10, they'll roll them. And at the bottom of that record, they'll actually also have slap impressions. And this is where they take the 4 fingers from your left hand, the 4 from your right, and they'll slap them down at the same time, so simultaneously, as well as your thumbs. And so we get that entire record, and then we can compare it to an unknown fingerprint. Same thing with palms. They're just going to try and capture as much of that palm information as possible for us to compare to any unknown palm impressions that we have.
And did you receive a known standard in this case?
No, I did not.
And did you receive anything to compare against from Scott Sessions?
May I look at my notes just to refresh my memory, please? Sure. Okay, thank you. No, I did not.
And may I approach for a moment?
Sure.
May I approach with Defense Exhibit NN?
Sure.
Can you see, and what is Defense Exhibit NN?
It appears to be a manila envelope containing finger/palm prints for Stanley Sess, S-E-S is how it's read here, taken by Officer Darcy Fedak.
And did you receive that?
No, it does not contain the laboratory label that we would receive on an item when it comes into the lab.
And what is a latent print? And how are they deposited?
A latent print is an unintentional recording of your friction-ridged skin when contact is made with a receptive item or surface. So I don't know if any of you have ever been really nervous and your hands get clammy. That's because those ridges that are present on your friction-ridged skin actually have sweat pores. And so at any given time, you can have sweat being released onto your friction-ridged skin. In addition to the sweat, your hands come into contact with your face and your hair, and so that contains oils. So again, at any given time, you could potentially have sweat and oil coating your friction-ridged skin. Other residues such as paint, oil, blood, dust, things like that could also coat your friction-ridged skin, thus allowing you to transfer an impression of your friction-ridged skin on the item or surface. So it's very similar to a rubber stamp. Think of your hand as the stamp, the ridges as the impression, and instead of ink, you have oil and sweat. And so when you touch that item, you're transferring an impression behind.
And what are the basic factors that make fingerprints useful for comparison?
So impressions of friction-ridged skin can contain morphological features that have a high degree of specificity that we can then use for comparison purposes. The friction-ridged skin is also relatively persistent throughout life.
Okay. And you've mentioned it a couple of times, a latent print of value. What is a latent print of value?
So when we receive an item in the laboratory, we're reviewing it to see if there are latents that we can use for comparison. And so that's what we're considering a latent of value. And to do that, we look at each impression independently, and we're looking at the quality and quantity of information in the latent. When we're talking about quality, we're talking about how clear and crisp the ridge detail is. And there's other factors that come into play that can actually alter the appearance of a latent impression, and we call this distortion. So think about when you touch an item, you're not just gently leaving a print behind potentially. There's going to be movement involved. If you're twisting a doorknob, for example, the amount of pressure that you're using to touch the item, is it a small amount of pressure, a very hard amount of pressure? So a lot of factors come into play when you're touching an item and leaving that impression behind. And so we have to look at that quality to see if it's good enough to move into comparison. Additionally, we're not just looking at that quality, we're also looking at the amount of information in the latent. And what we mean by that is the features that are present. So your ridges do independent things along your friction-ridged skin. And so, for example, you could have a single ridge in your fingerprint that is flowing along and it abruptly ends. We call this feature a ridge ending. You can have features that flow as a single ridge and divide into two, like a fork in the road. We call this a bifurcation. There are features that look like the period at the end of a sentence. We call those dots. And so we try to gather all these features to see if we can, how many we have and what we can use. And we don't just look at the number of features, we also have to look at the specificity of those features. What that means is the rarity of the features, as well as their location to one another, and what area of the friction-ridged skin that we're looking at. Because something to keep in mind is with latent impressions, we're not getting a fully formed fingerprint, we're getting a fragment or a small piece. And so individuals could potentially share features within this small area amongst the population. And so we have to gather those features and look at that rarity and look at their location and determine if it is useful for comparison.
Okay. And what framework do you use when conducting comparisons?
We use a framework known as ACE-B, and it stands for the Analysis, Comparison, Evaluation, and Verification Method.
Okay. And can you explain kind of generally the process that you go through when you are trying to identify any latent ridge detail or, before you make any comparisons?
Yeah, so that's what that process kind of helps us do. It guides us. So that analysis phase is what I just talked about. After we processed an item or viewed lift cards that we receive into the laboratory, we're looking to see if there's latents of value, looking at the quality and quantity. If we determine we do have enough information, we'll move into the comparison phase. And this is where we do a direct side-by-side comparison of that unknown impression to a known. And from there, we're looking at if there's any features that are in agreement or even in disagreement amongst the two. From there, we're going to move into the evaluation phase. Our lab has 3 conclusions that we can come to. The first is, is an identification. This is where there's sufficient quality and quantity of information in agreement amongst the latent and the known to determine that they were made by the same source. We have an exclusion. This is where there's sufficient quality and quantity of information in disagreement amongst the latent and the known to determine they were not made by the same source. And then we also have inconclusive. And we can come to this decision for a variety of reasons. One of the more common ones is we just have incomplete knowns. So a good example of that would be we have a tip region of a finger, and a lot of times on the temperament records they're not recorded. And so we have to go inconclusive because we don't have all the information. And then lastly, is the verification method. So once the original scientist has come to a conclusion, a second qualified latent examiner will come in and do their own analysis and comparison of that print to determine if they agree with the original conclusion.
Great. And to back up just a little bit, you mentioned processing. Can you explain how you might process an item that you receive?
Yes, it depends on the type of substrate that we receive in the lab. So what that means is you have porous substrates. Porous substrates absorb water. So that's typically paper items like an envelope, a letter, things of that nature. And then we also have non-porous items, which are items that do not absorb moisture. A cell phone, a gun, a knife, a can. So those are more common that we get. And then there's also semi-porous items, which can kind of contain both. That might be a or a glossy cardboard would be a good example of a semi-porous item. The glossy side's more non-porous, and the cardboard side is the porous. And so when we receive that item, we will determine what type of substrate it is, and then from there, what type of chemical processing we're going to perform.
Can you just briefly give an overview of the types of chemical processing that you can perform to develop latent prints?
For all substrates?
I would just kind of a brief overview. I know it's kind of
That's okay.
extensive.
So for a non-porous item, so again, one that does not absorb moisture, we'll say a pop can, for instance, we're typically going to process that using techniques known as superglue fuming, as well as dye staining. So we will fume the item in a superglue chamber, and the superglue essentially adheres to any moisture that's present on the item and turning any ridge detail in a white color. And then from there, we apply what's called a dye stain, and it fluoresces. So we're able to see and get better contrast of the ridge detail during that processing. And we can photograph at any phase, whether it's superglue or the dye stain, kind of how best we see the latent print at that time. In terms of a porous item, again, we have many chemicals, but we will apply the chemical to the paper-like item, and then we allow it to bake. It's very similar to an oven, if you will, and we just apply humidity and heat depending on the chemical, and then if there are any impressions present, they will react with the amino acids found in your sweat, and then we are able to visualize them.
Okay. And can you describe the difference between a latent print that is observed versus developed?
Yes, so sometimes we'll get lift cards that are, So actually, an observed impression would be one that we might see during a visual examination. So we would just open the item, and we're going to initially view the item to see if we see any ridge detail right away without any chemical processing. And we do note that in our worksheets. And then we'll continue on with processing, and then that would be something that we developed because we processed it.
Okay, and did you receive any items from law enforcement in this case?
Yes.
And can you approximate how many items or sub-items were submitted for latent print and examination in the case?
May I refresh my memory?
Yes.
By using my notes? Thank you.
And Judge, there were several submissions. It might be more helpful if we knew which reports and submissions.
Let me ask you this. Would it be fair to say there were about 80 items and sub-items submitted total between the multiple submissions in this case?
Potentially, approximately.
And I'm not going to go through all of those, probably to everybody's relief. But I do want to go through a couple of them if I have a moment to grab an exhibit.
Sure.
Your Honor, may I approach with People's Exhibit 171?
Sure.
Do you recognize this item?
Yes.
And was this an item that you tested?
Yes.
And so this item is, so People Exhibit 171 for the jury is, you assigned that and a unique item number for your lab, is that right?
Yes.
And that was item 4.1?
Yes.
And are those live 22 cartridges? Or a live 22 cartridge?
May I refer to my notes? So item 4 contained 3 live cartridges.
Okay. And did you find any ridge detail on that item?
May I refresh my
Yes.
memory? Yes, I did.
Were there any latent prints of value found?
No, there were not.
Were you able to make a comparison?
No.
Your Honor, may I have standing permission to approach?
Yes.
And so I'm approaching you with what has been previously admitted as People's Exhibit 151, which is duct tape from the Bluetooth wrapped around Sessions' head. Is this an item that you tested?
Yes.
And did you find any ridge detail on that item?
I will have to refresh my memory again.
That's fine.
So there were 4 pieces of duct tape that were separated from one another, and then additionally pieces of fabric that were also removed from the tape as a separate item. So one piece of tape did have ridge detail that was seen, but nothing was of value for comparison. And then the remaining 3 pieces of duct tape, there was no ridge detail seen at all.
Thank you. So I'm going to approach with People's Exhibit 165, which is gray duct tape from Tent 9, the basket kitchen counter. And I'll protrude those others for you.
Thank you.
And did you test that item?
Yes, I did.
And did you find any ridge detail on that item?
May I once again refresh my memory?
Sure. Okay, thank you.
Yes, there was ridge detail seen, but again, nothing of value for comparison purposes.
And I'm going to bring you People's Exhibit 111, which is plastic around the decedent sheeting around Frank. If I may approach.
Sure, what's that exhibit again? 111. Thank you.
And did you examine that item, People's Exhibit 111?
Your Honor, may I refresh my memory? I couldn't see the initials on there.
We don't expect you to have everything memorized.
Okay.
And if that helps you, it's item 12 from your report from June 11th, 2020. Oh, I'm sorry, item 7.
Yes.
Sorry.
Yes, I did analyze this item.
And did you find any ridge detail on that item?
Yes, I did, but nothing of value for comparison.
And I'm bringing you People's Exhibit 141.
Thank you.
You could look at your notes.
Thank you.
And those are the ammunition from a cooler, correct?
That's what it states, yes.
And did you examine that item?
Yes.
And what items or sub-items did you examine?
So it was broken down into sub-items. When we get multiple items in one item, that is something that we do at our laboratory. So it was broken down into 12.1 through 12.45. And item 12.1 was the empty box of Remington Thunderbolt 22 long rifle ammunition. And then items 12.2 through 12.45 were 22 cartridges.
And did you examine each and every cartridge in the box?
Yes.
And of the cartridges that you examined, were you able to observe or develop any ridge detail on any of those cartridges?
Ridge detail was seen, but again, on some of them, but again, not useful for comparison.
So there was not a latent print of value?
Correct.
And I'm going to approach with what's been previously admitted as People's Exhibit 144, which is a piece of black electrical tape from a spool of wire, if I may approach.
Sure.
Sorry, just had it.
Thank you.
And did you examine that item?
Yes, I did.
And did you develop any ridge, or observe or develop any ridge detail on that item?
So again, item 14 was broken down into sub-items. And so when I originally received it, I processed it as I received it, so as a whole, as to not damage any latent prints that may be present. And during that time, that first initial process, I found no ridge detail at all. Following that process, I then sub-itemed them. And so I have 14.1 through 14.5 were pieces of black electrical tape. And out of those 4 of them, no ridge detail was found. And 1 of them, I did see ridge detail.
And was that something that you considered to be a latent print of value?
No. So we can see ridge detail, but also it just is not considered of value. It doesn't have that quality and quantity of information to move into comparison.
So I'm going to approach with what has been previously admitted as Defendant's Exhibit QQ. Thank you. Can you tell me what that item is?
This is 14 fingerprint latents lifted off of toolbox that I received.
And how many print cards were there, if you can recall? Or refresh?
So that is what the label states, but I actually sub-itemed 4 latent lift cards.
Okay. And can you describe what a lift card is? I think you've done it a little bit already, but just to make sure we clarify that.
So a lift card is something we typically receive from either crime scene personnel or officers. So they will powder things at a scene that we typically can't take into the lab. For instance, a car, so the exterior of a car, we're not going to bring that into the lab to process it, so they'll powder it. And then they will, if they see any ridge detail, they will lift it and then submit it into the lab. Typically, anytime they lift anything, they'll also submit, even if they don't see any ridge detail, they also submit it. They just let us look at it. And so that's how we'll receive it in the lab, and then we'll look at it to see if there are any latents of value.
And did you observe any ridge detail on any of the 4 lift cards?
Yes, there was ridge detail on all 4, but nothing of value for comparison.
Out of all of the items you examined in this case, how many latent prints of value that were suitable for comparison did you observe or develop?
1 latent fingerprint.
And if I could approach with Defense Exhibit MM.
And like Mary?
Yes. Thank you.
And can you describe what that item is, please?
This is a latent envelope containing 2 lift cards with 2 latent lifts.
And was the latent print of value found on this item?
Yes, so there were 2 lift cards, 1.1 and 1.2, and I observed 1 latent fingerprint on item 1.2.
And did you use this latent print for comparison purposes?
Yes.
And what was your conclusion?
That latent 1.2-01 was compared and identified to the left index of Stanley Scott Sessions.
And so you had testified earlier that you weren't able, that you didn't receive a known standard for Mr. Sessions and hadn't received, I think it was Defense Exhibit NN. How did you make that identification to the left index finger of Stan Sessions?
So we have what's called the APHIS system, which stands for the Automated Fingerprint Identification System. And so when we have unknown and latent impressions, if they're of good enough quality, we can enter them into this system that houses civil and criminal records for the state of Colorado. This impression was entered, and that's how I was able to identify it to Stanley Scott Sessions.
And could we just clarify what MM is actually, what it's from?
Sure. It's been some time since it was admitted, so
Yes.
somebody let the jurors know.
Where I obtained the lists from, where the lists were obtained on.
What exactly MM is?
Oh, sorry.
Is it a latent lift card from a Ford Escape front door?
Yes, one is from the, and I can clarify this, I apologize, 1 second. One is from, 1.1 says it was from Ford Escape driver's door, and 1.2 was from Ford Escape front passenger door.
And the latent print that you identified was on which of those 2 that you just mentioned?
The Ford Escape front passenger door.
Thank you. If I can retrieve that exhibit.
Sure.
And that concludes my direct examination. Thank you.
Thanks, Eddie Cross.
Briefly. Good afternoon, Agent Rader. How are you?
Good, how are you?
Good. So I want to briefly talk to you about the latent prints or the latent lifts that were sent to you, the different items. And I just want to clarify the different reports that you did.
Yes.
So you did one report that was on February 18th of 2020. Is that right?
Yes.
And that was the one we were just talking about that came from a Ford Escape.
Yes.
And in that case, what you indicated was that you were able to have one fingerprint that you could identify that had enough ridge detail.
Yes.
And you were able to submit that into the APHIS system and get a conclusion.
So the APHIS system is a tool that we use, and how it works in simple terms is it will map out the features that are present in the impression, and then we can search it through the system. And in the state of Colorado, we're required to get back 15 candidates. So the system is looking to see if there are similar features within that database, and it brings back the top 15 that they felt were most closely similar. And then we have to go in manually and conduct comparison to each individual candidate to determine if we think there is an identification. And from there, we will take it to our desk and again perform a comparison, and then we get it verified from there. So that works.
And when you were able to identify a known fingerprint, and that would have been to Stanley Scott Sessions, correct?
To his left index finger, correct.
Thank you. And then I want to go to your June 5th of 2020 laboratory report. And there were several different items that were noted. So the first item, I believe that was noted, was item 19 on that particular report. Do you have that in front of you?
Yes.
And item 19, that was, it looks like burnt plastic from the scene, is that right?
Yes, and I broke that into two sub-items, item 19.1 and 19.2.
Okay. And there was an indication that there was no friction ridge detail, no ability to get a good latent identification.
Yes, there was no ridge detail found.
And I want to clarify, when you're talking about not getting in a good enough ridge detail, can you tell the jury what that means? What qualifies as a good ridge detail?
Again, when I was talking about that quality and quantity of information, that's what we're talking about. In this case, there was nothing to assess though. I saw no ridge detail at all, so I didn't have anything to look at to determine its value.
And when we're talking about things like People's Exhibit 171, the live rounds, which was your item number 4.4 and then 4.1, 4.2, and 4.3.
Yes.
Live rounds, is it often that you're able to pull enough ridge detail to get an identification for a latent print?
Typically, no. Due to the small surface area, we don't typically get latents of value on those.
And then I want to go to item number, I think it was 13, on that same report, which was done on June 5th of 2020.
Yes.
And you're talking there about duct tape, is that right?
Yes.
And duct tape from a blue cloth wrapped around Sessions' head.
Yes.
Is that how it's identified?
That's how it was submitted to the lab, yes.
If something has been exposed to smoke or fire or the elements, how likely is it that you will be able to lift any kind of print?
It does change things slightly. So if you think about sweat, it's mostly water. And so in a high heat environment, the heat can evaporate all of that moisture out of that impression. And so potentially by the time that we get it in the lab, we may not have anything for the chemicals to react with. And so that is a possibility.
And I want to talk next about Exhibit 111, the sheeting around Heather Frank. And that comes off of the report that you did on June 11th of 2020. Do you have that one in front of you?
Yes.
Plastic sheeting, so let's go to item 7, right? That plastic sheeting, can you talk about the kind of surface that you need to get ridge detail?
Typically, latent prints are left behind better on smooth surfaces, like the can of a gun, or pop can, or versus like a textured surface, like the grip of a gun, that's not as conducive for leaving latent prints behind. So smooth surfaces tend to be better.
And when we're talking about plastic sheeting, if it's also been exposed to the elements, does that make it more difficult?
It can potentially, depending on the environment it was in.
I think we already talked about all of the live rounds that you did. So that would have been item 12. Well, let's start out with the box, item 12.1, the empty box. You said that you looked at that, tested that, and there was no ability to have a quality lift. Is that correct?
There was no ridge detail found on that item.
And then the rest of those were live cartridges. We've already discussed that.
Yes.
And I wanted to talk to you about, I think it was the item that was the wire. So I think that was, and it was on the June 11th report.
that exhibit 144?
I believe so, yes. Wait a minute. I think it was actually on the June 5th report. I take that back. Do you have that exhibit in front of you by any chance?
Yes, the item 14 from the June 11th, 2020 report.
Okay.
Yes.
And that was that bunch of wire.
Yes.
Would it be common to find a good enough rich detail to give a good print on wire?
No, I actually did not analyze the wire because it's too small of a surface area for us to do any processing on.
I want to talk about the process of no known standards being sent. When you look at these items that are sent to you in a group like this, and you go through and try to see if there are quality latent prints, is it common to just send you all these known standards for you to run and then have nothing evidentiary-wise to be able to compare them to?
No, typically we don't receive knowns provided to us by the agency. We will attempt to look them up ourselves to see if they're present, and if not, we request them in our reports.
So, if there had been quality prints here that you were able to lift, you would have contacted the agents and said, send me some known standards.
Correct.
But that wasn't the case here.
Correct.
Nothing further. Thank you, Agent Rader.
Any redirect?
No, Your Honor, thank you.
Any questions from the jury? Looks like we do. You guys have your Bluetooths?
No, can I?
We were charging during the lunch hour.
Oh, thank you. Thank you.
Ms. Rader, the jurors have a question, and I've permitted this question. It reads as follows. How easy is it for a fingerprint of value to be deposited?
Well, it's dependent upon many factors. So it really depends on the condition of the time, condition of your skin at the time that you touch an item. So thinking back to that sweat and oil, sometimes you have too much residue, sometimes not enough. And so, for instance, maybe you just washed and dried your hands and you go to touch your water bottle. The odds of you leaving anything behind at that point are significantly low because you don't have any residue coating that friction-rich skin. On the opposite side of that spectrum, you can even have too much sweat and oil coating your friction-rich skin. And so that's why sometimes we'll see ridge detail, but it's not a value because maybe there's too much moisture and residue that were deposited as well as the ridge detail. And so we're not considering a value. And it also depends on the substrate surface that I talked about earlier. Is it a textured surface or a smooth surface? So there's very many variables as to whether you leave something behind at the time that you touch an item. So there's really not an answer to that because I don't know the skin condition at the time an individual touches it or for how long they touched it, things of that nature that all go into that.
Thank you. Any follow-up, Ms. Guthrie?
Your Honor, may
I apologize, yes.
Okay.
Ms. Morris, you get to go first.
So you talked about there's lots of variables. Is one variable also kind of the weather conditions that a person is in at the time? Does that make sense? So for example, sorry, you can answer. If not, ask a clarifying question.
Do you mean after the impression is deposited on the item and then weather happens?
Prior to it being deposited.
Potentially, again, if it's a summer day outside and it's really hot like today, you might be sweating more than usual. And then in the winter, it could be very dry. So you also, your condition of your skin may change depending on the elements of the weather, yes.
Thank you.
And you would also agree with the fact that if you're in a dry climate, generally, it makes it more difficult as well.
Correct.
Thank you. No further questions.
Any other questions from the jurors? All right, thank you. We appreciate your time. You're welcome to step down. May she be discharged from her subpoena?
Yes.
Thank you. Ms. Guthrie, is that okay with you?
Yes, she's actually not under our subpoena.
Thank you. Have a nice day. Next witness, please.
Your Honor, the defense would call Laura Bell.
Good afternoon. Before you sit down, I'm going to swear you in as a witness. If I can please have you raise your right hand, and do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth? Yes. Thanks. Once you have a seat, make yourself comfortable. Feel free to adjust that microphone. Once you're settled in, if I can please have you introduce yourself to this jury by stating your name and spelling your last name.
My name is Laura Bell, last name B-E-L-L.
Thank you. You're welcome to examine.
Good afternoon, Ms. Bell.
Good afternoon.
Where do you work?
I'm employed by the Colorado Bureau of Investigation.
And how long have you worked there?
I started in December of 2017, so almost 5 years now.
And what is your job title?
I am a forensic scientist in the drug chemistry unit.
And what duties do you fulfill in that position?
I analyze submitted items of evidence for the presence of controlled substances.
And have you ever worked for any other laboratory besides the Colorado Bureau of Investigation?
Yes, I was a forensic laboratory technician for the Albuquerque Police Department Crime Lab.
And do you have any particular education that assists you in performing your duties?
Yes, I have my bachelor's degree in biology, which includes organic, inorganic, and analytical chemistry, also supplemented with a course in quantitative chemical analysis.
And do you receive continuing education or training for subjects that are relevant to your field?
Yes, every year we try to do at least one external training in addition to reading applicable articles.
And have you ever previously testified as an expert?
Yes.
And is that specifically in the field of forensic or drug chemistry?
Yes.
And how many times have you testified previously as an expert?
Approximately 30 times now.
At this time, Your Honor, I would offer Ms. Bell as an expert in drug chemistry.
Any idea or any objection?
No objection.
So the court's going to find that Ms. Bell, pursuant to Rule 702, the rules of evidence, based on her knowledge, skill, experience, training, and education, is an expert in the field of drug chemistry, and may offer an expert opinion with regard to that subject matter.
And Ms. Bell, I'd like to turn your attention to the testing done in this case. Can you describe the general nature of the items you received for testing from law enforcement?
Yes, the items in this case were submitted in 4 separate items, which I then sub-itemed based on their general appearance, and then I proceeded with my analysis after that.
And what types of items did you separate out? Can you characterize those for us?
Yes, there were different vials of powders and liquid.
And about how many vials total were submitted?
I don't know the count offhand.
Does approximately 80 vials sound about right?
It could be. I don't know for sure offhand.
Would it refresh your recollection to take a look at your report for an approximate number?
Sure. Yes.
If you could do that, please.
Sure.
It does appear to be approximately that number of vials, although some of them were visually empty.
Okay, that was going to be my next question. Were they all full or were some empty? Some
did appear to be empty.
Did you do a visual examination prior to any testing of the items that you had received?
Yes.
Can you describe the type of cap that was on a majority of these vials?
To my recollection, many of them were metallic squeeze top that were clamped, as well as some plastic caps on top of them on some of the vials.
Okay, and those metal caps, did any of those have a rubber center?
I do believe that the metallic clamped tops did.
And what, in your experience, are those type of caps used for?
From what I've seen myself, they tend to be on bottles with liquids.
Okay. And were any of the vials punctured?
Yes.
Were any of the vials that you received labeled?
Some of them were.
And what was the item, 21.1, labeled as?
21.1?
Yes.
I would need to refresh my memory.
If it would do so, I'm sure the court would permit that.
Sure.
So item 21.1, I have documented from seeing on the label, Kigtropin human growth hormone.
Were there other items that had the same label?
According to my report, yes.
And what was item 22.5 labeled as?
22.5, according to my notes, adequine polysulfite glycosaminoglycan.
And what about the label on item 22.7?
22.7, according to my report, human chorionic gonadotropin.
And did you test any of the vials that had labels on them?
You may want to, why don't you go ahead and spell that for my court reporter?
Which one would you like?
The really big words.
Okay. Okay, so the last one that I mentioned, human chorionic, that's CHORIONIC, and then the word after that, GONADOTROPHIN.
Thank you.
You're welcome.
And so you said you didn't test any of the labeled vials, is that right?
Correct.
And why is that?
The item that I started with, I identified a controlled substance that for that particular substance was over the maximum weight threshold, so I was able to cease analysis.
Okay. And so we'll get kind of to that a little bit. You got a little bit ahead of me, but did you test every item or vial that was submitted?
No.
And do you rely on the labels on an item if you were to test that item?
No.
And so because you made an identification of a controlled substance on an item you did test, why is it that you didn't undertake any additional testing?
Should I have analyzed additional items of evidence within this case, it would have been essentially, if I were to identify the same controlled substance, it would have been in excess of the maximum applicable weight threshold that I had already met by analyzing one of the vials.
Okay. And if I may approach, Judge?
Yes.
So I'm approaching with what has been previously admitted as Defendant's Exhibit V as in Victor. Do you recognize this item?
Yes, I do.
And what is it?
This is an item that I analyzed in this case. This is CBI item 22 in this case.
And can you describe for the jury what's inside that item?
So inside this exterior bag is the exterior packaging that was originally the most exterior when I received it. The CBI corresponding label is on that. And inside is a box containing various vials. Excuse me.
If I could retrieve that.
Sure.
And before you begin testing items, do you check to see if the items are sealed and document the seal condition?
Yes.
And did you do that in this case?
Yes, I did.
And generally speaking, how do you go about testing an unknown substance to determine what is in the item?
So when I originally open an item, I document what the exterior packaging is, what the seal looks like, if it's properly identified. I then proceed with sub-iteming, which I did in this case, if it's necessary. And then I proceed with a presumptive as well as instrumental confirmatory analysis on the items.
And what type of instruments do you use to test, or did you use in this case, to test for controlled substances?
In this case, I used two different types of instrumentation, one being the acronym an FTIR, and the other one having an acronym a GCMS.
And could you explain what that is for those of us not familiar with the acronyms?
So the long term for the FTIR is a Fourier transform infrared spectrometer. And the long name for the other one, the GCMS, is a gas chromatograph mass spectrometer.
And did you test the instruments and balances to make sure they were functioning properly before you used them?
Yes, they are tested every week prior to being used on casework.
And what was, prior to undertaking any of the tests with the instrumentation, did you take a weight of the items?
On the one I analyzed, yes, I did.
And what was the weight of that item?
10.97 grams.
And you had mentioned earlier that it was above a particular threshold. What What is that threshold, I guess?
For the substance that I identified, the threshold is 4 grams.
Okay, and did you identify anything in the item?
Yes, I did.
What were you able to identify?
A substance called trenbolone acetate.
And
Spell that for us, please.
Yes, TRENBOLONE, and then acetate, ACETATE.
And what is trenbolone acetate a controlled substance?
Yes.
And what kind of substance, to back up, what schedule controlled substance is it?
It's a Schedule 3.
And what kind of substance is trenbolone acetate?
It is considered an anabolic steroid.
If I could have a moment? Nothing further, thank you.
Thanks. Any cross-examination?
Great. Good afternoon, Ms. Bell.
Good afternoon.
You said you did not test the items that already had a label on them, is that correct?
In this case, that's correct.
Okay. And so if it's true that the items contain what they were labeled to be, would those items have also been an illegal substance? So let me give you an example here.
Please.
For example, their item 22.6 was a manufacturer's box labeled Kigtropin human growth hormone. If it were to have tested positive for what it was labeled as, would that be an illegal substance?
I am not sure, to be honest. It could be.
Okay. You didn't bother to compare the label to what that might equate to in terms of the controlled substance list, is that correct?
Would you mind repeating that, please?
Sure. Labels don't always scream out, hey, I'm illegal, right?
Right.
So you didn't look up Kigtropin, human growth hormone, to see what that might equate to in terms of what is in that type of human growth hormone.
I believe I may have afterwards for curiosity's sake, but I don't recall what I found.
Okay. Was it curiosity because you hadn't seen that kind of thing before?
I had not.
One of these items was labeled as intramuscular use in horses, is that correct?
I do believe that's what the label said.
And are these kind of things, such as and I don't know that I want to even try to, well, let's go to Kigtropin, because I can pronounce that one. Is that something that you can just order through the mail?
I do not know how someone might get a hold of it.
Okay. No further questions, thank you.
Any redirect on those limited issues?
Yes. Was the vial that you tested the only unlabeled vial?
To my recollection, no, there were other ones that were unlabeled.
And what was the color of the substance?
The one that I analyzed was an orange liquid.
Were any of the other vials labeled or otherwise similar in appearance based on the color?
They were similar in color.
Thank you.
Any recross? No, you're not. Any questions from the jury? Okay, thank you. You're welcome to step down. We appreciate your time. May she be excused from her subpoena. Discourse.
Yes.
Thank you. Appreciate your time.
Thank you.
Next witness, please.
Your Honor, the defense calls Blake McLaughlin, who's present in the courtroom.
Thank you. Good afternoon. Please have you raise your right hand, and do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth? Yes. Thanks. Why don't you have a seat, make yourself comfortable. Feel free to adjust that microphone. Once you're settled in, if I can please have you introduce yourself to this jury by stating your name and spelling your last name.
My name is Blake McLaughlin, McLaughlin.
Thank you. You're welcome to examine.
Thank you. Good afternoon, sir.
Good afternoon.
Mr. McLaughlin, what do you do for a living?
I work for PepsiCo.
Okay.
I basically just stock Pepsi.
Did you get a good discount?
No, sorry,
Alright.
not.
Is Alex McLaughlin your brother?
Yes,
Was Miss Heather Frank your mother?
yes,
Is there another sibling?
yes. Christian McLaughlin?
And are the two of you twins?
Yes, identical.
Identical. So we're sure we have Blake here?
Yes.
Okay. Mr. McLaughlin, how old are you?
25 now.
25, okay. And you just testified that Miss Frank was your mom. Do you remember the last time you saw your mom before her death?
Yes, I don't remember the exact day, but we decided to go eat at
Okay.
Alberto's here in Greeley.
Okay.
I don't remember the exact time. I think it was like seven-ish.
Okay. So I want to take you back a little bit before that time, okay? You said a moment ago that there was a decision made to go out to eat. Was that decision made in person, or on the phone, via text, via email?
Over phone.
Okay. Did you call your mom earlier that day?
Yes,
Was it the same day that you went out to dinner?
yes.
Did you call your mom for any specific reason, or just sort of check in?
Just to check in, see where we want to eat.
Okay. And was that around 4 o'clock that day?
I'm sorry, what?
Was that around 4 o'clock that day?
I believe so, yes.
Okay. And the day we're talking about, was that the Tuesday before she passed away?
I'm not too sure.
Okay. Do you remember speaking to an investigator, Vita Servine, with the Larimer County Sheriff's Department?
I believe so.
A female investigator
Yes.
with Larimer? Okay. Is it fair to say that you may not know her full name?
Yes, I do not.
Do you remember telling her that you had dinner with your mom on Tuesday night?
Yes.
Okay.
I do recall that it was Tuesday, I just don't remember the day.
Okay.
The number.
That's perfectly fair. But was it the Tuesday before you learned your mom passed away?
I'm sorry, what?
That's fine. Was that the Tuesday before you learned that your mom passed away?
Yes.
And when you called your mom earlier to check in that day and to orchestrate this plan, how did she seem?
She seemed normal to me. We literally talked about family, what we're gonna do in August, because usually we like to go out to Colorado Springs.
So we'll get there for a moment. I'm just wanting to see just her general tone when you talked to her on the phone. When you talked to her on the phone, did you learn that Mr. Eastman was back in Colorado?
Actually, yes. I heard whispers,
Okay.
and it I knew who it was.
Did you know who it was because you were familiar with Mr. Eastman?
Yes.
Were you familiar with Mr. Eastman being your mom's ex-boyfriend?
Yes.
Were you under the impression that Mr. Eastman had moved to Arizona?
Yes.
So is it fair to say that you were surprised to hear Mr. Eastman in the background when you called your mom that day?
Yes.
And you indicated that the decision was made to go out to dinner at Alberto's?
Yes.
Is that Alberto's Express or just regular Alberto's?
I think it's Alberto's. I haven't been there since. It's off of West 10th and 26th Ave, I believe.
And that's here in Greeley?
Yes, ma'am.
And about what time did you arrive at Alberto's for dinner?
I can't quite remember. It was dark, so I
Okay.
believe probably after 6.
And did you meet your mom and Mr. Eastman at their residence and then go to the restaurant? Or did you all meet at Alberto's?
No, but I was there first.
Okay.
Waited 10, 15 minutes, then
Okay.
they showed up.
And by they, can you explain who you mean by that, please?
Heather Frank and Kevin Eastman.
Your mom?
Yes.
Okay. And was there someone else present?
Yes, my girlfriend was.
Okay. And Alberto's is a Mexican restaurant, is that correct?
Yes.
And can you kind of just explain to the jury how that dinner went that night?
Pretty quick, to be honest. It felt like 45 minutes. I already ordered my food and my girlfriend's food. When they came and sat down, they ordered pretty quickly. Talked for a half hour. Told her goodbye, like love you, bye, and they left. It was snowing too as well, so I wanted to get out of there pretty quickly because I have a rear a coupe pretty quick. It's really harsh in the snow.
Okay. And let's talk about just the general demeanor or feel of that dinner for a second, okay? I think you started to talk about it, but was there just general small talk without going into detail about what was said?
Yes, it was mainly just between me and my mom.
Okay. And was there some general discussion about football?
No.
Do you remember telling Miss Rita Servine on your interview on February 6, 2020, that there was some discussions about football?
I do not remember.
Okay, would it refresh your recollection to listen to the recording of that?
Yes.
Okay.
And if council could tell me where on the report that's related, I'd like to see that.
I'll give you the timestamp in 1 second. Should be at 15:06. May I approach this witness, Judge?
Sure.
Thank you.
Could you play it one more time?
Sure thing.
Almost sounds like Christian. Almost does.
Is it you though?
Yes, that is me. Yeah.
I know it's been a long time. Did that refresh your recollection, Blake?
Not really. I mean, like I said, I mainly talk to my mother.
Okay. So it's your testimony today that you didn't tell Mr. Bean on February 16th, 2020, in the recording that we just listened to, that there was some discussion about football.
Yes.
That's your testimony.
I just don't remember talking about football specifically, but
So the question is whether that recording that you just heard, did that help you refresh your memory about that conversation?
No, not really.
It doesn't? Okay.
So it's your testimony today that you did not tell Investigator Servine on February 16th, 2020, that there was discussion about football.
I did.
You did tell her that?
Yes.
Okay, thank you. And I also believe you started to say this earlier, but just in case, there was also a discussion about visiting family in Colorado Springs?
Yes.
And also, was there a conversation about visiting and what kind of activities the family would do in general?
Yes.
And is it fair to say you ate and had a good time?
Yes.
And did you also You indicate that you mostly talked to your mom that night?
Yes.
And your mom didn't seem any different to you that night?
No, not that night, no.
And again, you knew Miss Frank well, she was your mom.
Yes.
And was there, well, let me ask you this, did you know your mom to be outgoing?
Yes.
Did you know her to go out and about concerts or see live music?
Yeah, all the time.
Did she ever mention anything to you about a Scott Sessions?
No.
And you also knew of your mom's relationship with Mr. Eastman.
Yes.
And you knew that relationship was rocky.
Very, yes.
You knew that there were times when the two of them would split up.
Judge, I'm going to object as to leading.
I'll rephrase it, Judge. Did you know if there were times where the two would split up and separate?
Yes.
Was there numerous times that they would separate?
Yes, ma'am.
And did you ever know Mr. Eastman to be a jealous man?
No.
Nothing further. Thank you, Blake.
Thank you. Any cross-examination?
Yes. Good afternoon, Mr. McLaughlin.
Good afternoon.
So I want to talk to you about that interview that you had with Ms. Serving, investigator Serving from the Larimer County Sheriff's Department. She talked to you on February 16th of 2020, right?
Yes.
And when she spoke with you, she had asked you about having dinner on Tuesday night and asked you if that was correct.
Yes.
And do you remember telling her, no, that's not correct, I'm pretty sure it was Monday night?
I was working that week. I just got off work at 6 a.m., fell asleep. My mind could have been just blurry, but I believe it was a Tuesday.
So that would be February 11th, right?
Yes.
And when you were speaking with Ms. Servine, she had indicated to you that Monday was February 9th, but it's actually February 10th, right?
Right.
So when you went out to dinner with your mother, and when you were speaking with Investigator Servine, she asked you if anything seemed odd or amiss. Do you remember that?
Mm-hmm.
I'm sorry.
Yes.
Thank you.
Sorry.
It's okay. When she asked you if anything was odd or amiss, you said, well, just basically my mom,
Yes.
right?
Yep.
And you also stated that you knew that things were going good for a while, but you guessed that she doesn't want to work things out with Kevin, right? With him.
Yes.
And you had indicated to Investigator Servine that that was odd because she didn't want to be with him, but he wanted to be with her.
Correct.
You'd also, when you were speaking with Investigator Servine, that was, you noted that was the last time you saw your mother, right?
Yes.
And that was the last time that you spoke to her.
Yep.
And your mom didn't pass away, right? Your mother didn't just pass away, right?
Objection vague.
I'm not too sure what you mean by that.
You can be direct.
Sure. Your mom was murdered. She didn't just die of natural causes.
Right. Oh, yes.
Relevance.
Overruled.
On that particular day when you went and had dinner with your mom and the defendant, when you spoke with Investigator Servine, you had told her that you found out that he was back in town when you called your mother,
Objection, hearsay.
right?
Why don't you want to respond to that objection?
Yes, Judge, it is not hearsay. It's actually prior inconsistent statement after testimony.
Why don't you re-ask the question again?
Sure. So you just testified that you had called your mother, right?
Yes.
And you said that you had called your mother on that night before you went out to eat, right?
Yes.
Okay. And that you had spoken with her on that night, which was the Tuesday night, right, that you were going to go out to eat?
Wait, I'm sorry. Yes, actually, it was, I'm not too sure what the day was. I know it was a Tuesday, because my schedule was, it's 7 days a week. I was working at Rival. So when I got off, which was, I believe it was the 9th or 10th, I did call her to ask to have breakfast, but she told me she couldn't because
Objection, hearsay.
So I'm going to sustain the objection.
So without telling me what your mom said, so I need to make sure that we know, like, the dates. So you talked to your mom on one day, and then did you have dinner on the next night?
Yes.
Okay. And so since you had dinner on February 11th, which was the Tuesday, right?
Yes.
Then you would have talked to her on the 10th
Yes.
to make that arrangement.
Yes.
When you called her, did you hear the defendant on the phone with her?
I heard him whispering at first, and then he started talking.
And when you heard him whispering, did he say anything at that point?
Objection, hearsay.
Overruled.
I think he, as I remember, he said he wanted us to go out to dinner in the afternoon.
When you spoke with Investigator Servine on February the 16th of 2020, do you remember telling her that you heard the defendant said, "Yeah, I'm back"?
Yes.
And do you also remember when you spoke with Investigator Servine, you indicated to her that you were afraid, you had some fears about your mom being with him
Yes.
because of past stuff?
Yes.
When you spoke with Investigator Servine, what caused you to believe that your mom didn't want to be with Kevin?
Objection, speculation.
So can you answer that question without guessing?
Yes, I can.
Okay.
Your Honor, I'm also concerned that we may be getting into some 404B that hasn't been offered previously or accepted by this court.
Okay.
I don't believe that it is. There's been a lot of testimony about what her oldest son saw.
If you want to ask a specific leading question, you're certainly welcome to do that to avoid that issue.
Sure. So, did you tell Investigator Servine that you believed your mother didn't want to be with him because of the past and because he's an alcoholic?
Yes.
Thank you. I have no further questions, Judge.
Thank you. Any redirect examination?
Yes, sir. Sorry, Blake. Sorry, Mr. McLaughlin. So Ms. Guthrie just asked you some questions about your mom's concern for her safety. Okay.
Yes.
And as we've heard, you spoke to Ms. Servine on February 16th, 2020.
Yes.
And was that before you found out about your mom being deceased?
I'm sorry, one more time?
Was that before you found out your mom was deceased?
I'm going to object to that characterization.
The word deceased?
Yes.
I'll overrule the objection. You can certainly use that word as well.
I'm sorry, I'm just trying to be a little bit more.
Could you rephrase that? I'm sorry.
Sure. Was that when you spoke to Ms. Servine, again, the female investigator from Larimer, do you just recall if that was before or after you found out your mom passed away?
Believe it was after she told me.
Okay. And again, Ms. Guthrie just asked you some questions about your mom's fear for her safety. When you spoke to Investigator Servine on February 16th, 2020, were you asked if you knew whether your mom essentially would call someone if she thought she were in trouble?
Yes.
And did you believe that your mom would call your dad if she thought she was in trouble?
Yes.
Did you also think or knew that your mom would call the police if she thought she was in trouble?
No.
Do you remember telling Investigator Servine on February 16th, 2020, quote, "But I know she would do the right thing, either call the cops or have him," meaning Mr. Eastman, "get out of there"?
I'm sorry, what?
I know, it's nerve-wracking. Everyone's looking at you. I totally understand.
No, it's fine. It was a little...
No, that was probably my fault too. It's probably a bad question. Do you remember telling Investigator Servine on February 16th, 2020, when again she was asking about your mom's safety and your concerns about it, quote, "I know she would do the right thing, either call the cops or have him," meaning Mr. Eastman, "get out of there"?
Yes.
Do you recall also telling Ms. Servine that you knew that Mr. Eastman would listen?
Yes.
Nothing further. Thank you, Blake.
Any recross?
No.
Any questions from the jury? Okay, thank you. You're welcome to step down. May he be excused from his subpoena.
He is. Thank you, Blake.
Thanks. You're welcome to remain in the courtroom or leave. It's up to you. Thank you. Next witness.
Judge, can we have a Bluetooth just for scheduling, please?
Yeah.
Thank you, sir.
So our next witness is going to be a little bit lengthier than the last few witnesses, and so rather than starting the witness's testimony and then taking an afternoon break in 10, 15 minutes, we're going to just take an afternoon break now, and then we'll get started with the witness's testimony, okay? Again, please don't discuss this case with anybody, don't do any independent research, please don't listen to any news reports, and please do not form or express an opinion about the case until it's finally submitted to you. We'll see you back here, why don't we say 3:05, 3:10 or so, does that work? Okay, let's all rise for the jury. Okay, you're welcome to be seated, or we're in recess. You're welcome to stay or go. Are we ready?
We are. This Tyler from my office is bringing something over really quickly, just so we can get started.
Okay.
I just didn't want the court seeing her approach and think something was up right now.
Okay, we're back on the record. People versus Kevin Eastman, 20 CR 461. It's 3:09. We're outside the presence of the jury. Parties are all present. Any other issues before we get started?
New York.
No, sir, thank you.
Okay, let's bring the jurors in. All right, welcome to be seated. Ms. Deborah, you're welcome to call your next witness.
Thank you. The defense calls at this time Ms. Shelley Brinklow.
Good afternoon. I'm going to have you come around to the witness stand over here. And before you sit down, I'm going to swear you in as a witness, okay? Can you please raise your right hand? And do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth? Yes. Thanks. Why don't you have a seat to make yourself comfortable? Feel free to adjust that microphone. Once you're settled in, if I can please have you introduce yourself to the jury by stating your name and spelling your last name.
My name is Shelley Brinklow, and my last name is spelled Brinklow.
Thank you. You're welcome to examine.
Your Honor, before we do that, can we just have a brief Bluetooth conference?
Sure.
Thank you.
I'm sorry about the delay. We got to take up an issue outside of your presence. Shouldn't take very long, so if we can please go back into the jury room, we'll call you back in here as soon as possible. Okay, welcome to be seated. Okay, we are outside the presence of the jury. And Ms. Brinklow, the prosecutor is going to ask you some questions. Ms. Devereaux may ask you some questions. We wanted to do this outside the presence of the jury. Mr. Wren?
Thank you. Good afternoon, ma'am.
Good afternoon.
Prior to going by the name Shelley Brinklow, did you ever go by the name Shelley Kissel?
Yes.
Okay. And under the name Shelley Ray Kissel, were you previously convicted of manslaughter?
Yes, I was.
Okay. No further questions.
And that was a felony?
Yes, it was.
What year was that?
1988.
Okay. Any questions, Ms. Devereaux?
Sure.
I don't have any questions for her, just argument though.
Sure.
And I think this is fine to do it in front of her, but my concern is that the information that we have from, again, just receiving it now from the prosecution, the NCIC is inconsistent with that. It specifically, well, first of all, it doesn't say the actual date of conviction, and I believe under case law, which Ms. Morris is gonna pull up again, there has to be the scope of questioning is generally limited to the name, nature, and date of offense for which the witness was convicted, and that's People v. HUYNH, and that's found at 98 P. 3rd 907, and it's a Colorado Court of Appeals case from 2004.
And I agree with that, the key word being limited, meaning no more than, as opposed to the minimum required to bring it up. That's the difference. I agree with that statement, although with an alleged second conviction for theft, much like you did of prosecution witnesses pursuant to People v. Segovia, 196 P. 3rd 1126, not only can they bring up the felony conviction, but the underlying facts dealing with the issues of untruthfulness, much like you did.
I agree with that for the theft. I don't believe the charge of manslaughter would have.
Agreed.
Okay.
And I agree too, and I am not intending to dive into any more than what was just discussed.
Right, so the key word there is limited to, not minimum requirement.
So under People v. Thompson, which is at 511 P. 2nd 909 and Penn site 910, it's a Colorado Court of Appeals case, Colorado Supreme Court case from 1973. In that case, the court indicated that questions about prior felonies must be asked by the prosecuting attorney in good faith. And the only way that counsel can establish good faith is if the defendant denies any prior felony convictions to make an offer of proof to the court. She clearly did not do that. However, there's still underlying concerns about how she indicated that her conviction was from 1988 under oath. And Mr. Wren does not have consistent information with that. All this NCIC says is that she was arrested in 1998, but there's no date of actual conviction.
So the best evidence, I think, that we have today is the witness who was a defendant who, under oath, tells the court, I have been convicted of a felony, namely manslaughter in 1988. If you want to impeach her as to the year that she was convicted, you can certainly do that. So the court is going to allow the prosecution pursuant to 1390-101 to use those two felony convictions for purposes of impeachment. And if they want to get into the underlying facts in the theft felony conviction, they can do that pursuant to People versus Segovia, but not on the manslaughter conviction.
And I just want to make for a record that we can't do any kind of impeachment because that's the whole issue. We don't actually know the date of conviction. We don't have that record.
Okay. That is a Colorado case, and I thought you said you had access to data.
Remember, this is the manslaughter case is the case that's not on data access, so we can't determine a date of conviction. And there's also no way for us to know that information because we don't have access to NCIC.
If you would like to speak to your witness before we get started, you're welcome to do that.
Yes, please.
If defense counsel's asking me not to include the date of conviction, that's fine. I will simply say a prior felony conviction for manslaughter.
And I think that's prejudicial because that could insinuate it happened yesterday.
This witness, under oath, is saying, I have a felony conviction for manslaughter in 1988. That information is admissible under 1390-101.
We have a minute with Ms. Brinklow, please.
Yeah. Okay, we are back on the record outside the presence of the jury. Ms. Brinklow, you're welcome to resume the witness stand. Anything else before we get started?
No, thank you.
Okay, let's bring the jurors in. Okay, welcome to be seated. Sorry about the delay. And you are welcome to examine Ms. Deborah.
Good afternoon, Ms. Brinklow.
Good afternoon.
Ms. Brinklow, can you tell this jury a little bit about yourself to start with? Let's ask you, what do you do for a living?
I'm an insurance inspector.
So the microphone, if you could turn the microphone closer to you and pull it closer to your mouth. The microphone moves, but the chair does not.
Okay, there we go. Is that
Okay,
better?
Yes, thank you. What do you do for a living?
I'm an insurance inspector.
And how long have you been doing that?
Oh, close to 20 years.
Okay. And what did you do before that?
I do this full-time now.
Okay.
Before, I worked for a law firm for 17 years in Glenwood Springs.
Okay. And what type of law firm was that?
The boring type, probate, water, contractual things.
Okay. And Ms. Brinklow, do you know Mr. Kevin Eastman?
Yes, I do.
Do you know Mr. Kevin Quintana?
Yes, I do.
Are they both your brother?
Yes.
Okay.
He is.
Is Kevin,
So, same person, not two different, same person, right?
Same person, yes.
that's what I was just gonna get to. Okay. Do you know what Kevin's born legal name was?
Full name?
Yes.
Kevin Dean Quintana.
Okay. So was Quintana his, or let me ask you this, did he eventually change his name to Mr. Eastman?
Yes, he did.
Do you know if, where he got that last name Eastman from?
His wife.
Okay.
At the time, yes.
Was that Billy Eastman?
Yes, it was.
Okay, so he took on
Her name,
her
yes,
name?
he did.
Okay, instead of the opposite?
Yes.
Okay. Thank you for clarifying that. How many brothers and sisters do you have?
On my mom's side or my dad's side?
All of the above.
Okay, so I am the oldest of both sides.
Okay.
I have a brother and two sisters on my dad's side.
Okay.
And then I have two brothers and a sister on my mom's side.
And does that include Mr. Eastman or Quintana?
Yes, it does.
We'll call Kevin. Okay. And is it fair to say that you love your brother, Kevin?
Yes, that's fair.
Okay. Is it fair to say that you two were quite close growing up?
Yes, we were very close.
Can you describe from the jury the nature of your relationship?
Through childhood or now?
Let's start with childhood.
We grew up in the same household for the most part. We're only 4 years apart. We were very close, mischievous, couple fights, but for the most part, we always got along pretty well.
Okay. As the two of you grew into adulthood, did that relationship turn more from brother and sister to, or let me ask you this way, did you develop or become more of like a motherly figure to him?
Yes.
Did you guys have the same mother or different fathers?
The same mother.
The same mother, okay. Is it fair to say that your mother wasn't necessarily around much growing up?
She was not.
Okay. Did you and Mr. Eastman have different sets of grandparents?
Yes, we did.
Were there occasions where Mr. Eastman would go to one set of grandparents and you would go to another set of grandparents?
Yes, I stayed stationary with the older grandparents, the great-grandparents, and Kevin was shuttled back and forth between the two sets of grandparents.
Okay. Now, when you were 19 years old, we're going to talk about something that isn't probably the most pleasant, and I apologize for that.
Okay.
Were you in a very dangerous relationship?
Yes, I was.
Were you, or can you describe for the jury what you mean by a dangerous relationship?
I was in a domestic violence relationship with my live-in boyfriend.
Okay. And at some point, or let me ask you this, when you say domestic violence, were you the one being abused?
Yes.
And ultimately, one day, was there an incident of you being abused, and during that, you had to defend yourself?
Yes, I did.
And during an incident of being abused, did you kill that man?
Yes, I did.
And as a result, do you have a felony conviction from the late 80s of manslaughter?
Yes, I do.
And in wrapping up that case, were you actually given a probationary offer?
Yes, I was.
Relevance. Staying.
Okay. Later in life, or let me ask you this: so you were 19, you took care of that matter, and later, when in adulthood, in the year 2013, did you get in trouble again?
Yes, I did.
Was that a felony in 2013 for theft?
Yes, it was.
And in that situation, or can you explain the circumstances of that conviction?
My ex-husband and I, he'd been unemployed for quite some time. We were raising our disabled grandkids and didn't have any income or anything from the parents. And we took appliances. I was doing foreclosure inspections as an inspector, and we did take appliances from a foreclosed home and sold them. Yes, we did.
Thank you. And I'm not saying this to embarrass you at all.
No, I know you're not.
So now you've certainly seemed to have turned your life around. You said you're an insurance adjuster?
Inspector, yes.
Inspector. Can you explain where you currently live?
I live in Pueblo, Colorado.
And how long have you lived in Pueblo?
Almost 2 years.
And in the beginning of 2020, were you living at Pueblo at the time?
No, I was not.
Where were you living?
Parachute, Colorado.
Approximately how far is Parachute, Colorado from here? Either in hours or miles or however you want to.
6 hours, probably 260 miles, I'm assuming.
And how long did you live in Parachute for?
15 years. Oh, no, that was the second house. Moved there in September of 2000.
Okay.
And until July of 2020.
Okay. And in late 2019 and 2020, what was the address in Parachute you were living at?
265 Meadow Drive.
Okay. And who lived at the residence in January 2020?
Everyone that lived there?
Yes, please.
Myself, my husband Jerry, my daughter Mallory, my son Tanner, and my 3 grandchildren whom I have custody of.
Okay. And when you say your daughter and your son, are they your biological children?
Yes, they are.
Okay. And you said you also have custody of your 3 grandchildren?
Yes, I do.
And do those grandchildren have any kind of special needs?
All 3 of them do, yes.
Sustained.
Now, at some point, or let me ask you this, have you been contacted by law enforcement about this case?
Yes.
Have you been contacted multiple times by law enforcement?
Yes, I have.
And again, do you love your brother?
Oh, yes, I do.
Were you cooperative with law enforcement about this case?
I gave the information I felt comfortable giving, not knowing the facts of the case. Yes, I felt I was cooperative.
Were there occasions where you may have had physical items and evidence that you chose not to hand over to law enforcement?
Yes.
And what was your reasoning for that?
This is when the case had progressed. I realized that my brother's a suspect.
Okay.
And I had items that were my work product.
Okay. And is it fair to say that you wanted to help your brother?
Of course.
You wanted to protect your brother?
Yes.
And have you told, or let me ask it this way, were there occasions that you told law enforcement that you would not help them prosecute your brother?
Yes, I did say that.
But did you make it clear that while you may not help them, you weren't going to lie for him?
That's exactly what I said.
Leading, hearsay.
Right, so the court is going to sustain the objection based on leading and hearsay.
Well, let me ask you this. Just because you love your brother, does that mean you're going to commit perjury today?
Absolutely not.
Okay. Is your brother an angel?
No, he's not.
Okay. Do you know someone named Heather Frank?
Yes, I do.
How do you know her?
I met her through my brother, Kevin.
Okay. And approximately what year did you first meet Miss Frank?
Summer of 2013, I believe.
And at the beginning of, was that the beginning of the relationship?
Yes.
Would Mr. Eastman bring Miss Frank to family events?
Yes.
Would those family events be frequent or infrequent?
Considering the miles that separated us, frequent. Every other month, we would meet.
And were you in Parachute at that time as well?
Yes.
Did it appear that Mr. Eastman was proud of his relationship with Miss Frank?
Absolutely.
Objection foundation.
It laid the foundation of they saw each other every other month.
Then it's hearsay.
It's not, I'm not listening to a statement, I'm just saying, did he appear? It's his physical appearances.
So based on your observations, not comments made by your brother to you, could you answer that question?
Yes, I can.
Why don't you go ahead and do that again?
Did it appear that Mr. Eastman was proud of his relationship with Miss Frank?
Yes, very much so.
Have you seen your brother sad before?
Yes, I have.
Have you seen your brother happy before?
Yes, I have.
At the beginning of the relationship, did it appear that Mr. Eastman was happy with Miss Frank?
Yes, he was very much so.
Had you seen your brother, or let me ask you this, do you know how long Mr. Eastman and Miss Frank were in a relationship for?
From 2013, the first time that I met her, up until 2019, probably summer.
Okay. Was the relationship consistent, or was the relationship on and off?
There were times that they were on, and there were times they were off.
Did you have many opportunities to observe the couple interact over the years?
Many, yes.
Were there times that you would spend days on end with the couples, the couple being Mr. Eastman and Miss Frank?
Yes.
Would you go on trips with Mr. Eastman and Miss Frank?
That's usually what we did.
Okay. Were those trips overnight?
Yes.
And did you get to know Miss Frank throughout that process?
Yes, I did.
How would you describe Miss Frank?
Objection vague.
Why don't you be a little bit more specific about that, please?
How would you describe Ms. Frank in terms of how she would interact with Mr. Eastman?
Like, I mean, throughout the whole relationship, or?
Let's talk about the beginning of the relationship.
Okay. They were very affectionate.
Okay.
They laughed a lot. They had.
I'm going to object as to the relevance of how they interacted in 2013.
Can the parties please go on Bluetooth?
At some point, did the relationship between Mr. Eastman and Ms. Frank essentially deteriorate?
Yes, it did.
And
All right, again, I'm going to object as to foundation or hearsay. It's one or the other.
he just said that he was going to.
Wait. So, without telling us what your brother told you, you can, based on your visual observations, you can certainly tell us when you believe the relationship became volatile, if that's what you believe it became. Okay?
Okay.
The word I used was deteriorate.
Deteriorate.
Okay.
Again, I was trying to lay the foundation. Did you at some point see the relationship deteriorate based only on your observations?
Yes, I did.
Okay. Can you tell this jury approximately when that was?
2015.
And what did you observe without getting into any statements that anyone made that led you to believe that?
The bantering between them had become pretty close to non-existent. There was a lot of disturbance. Heather became very snippy, kind of withdrawn at times when we were around her.
Okay. Do you know if, and again, based only on your observations, not on anything anyone told you, okay? Do you know if your brother proposed to Mr. Eastman before? I mean, sorry, your brother proposed to Ms. Frank before?
Yes, I do know that.
How many times?
3, maybe 4.
Okay.
If I'm recalling correctly.
Did you ever attend a wedding?
No. No, I didn't.
I mean, a wedding in general, specifically a wedding with Mr. Eastman and Ms. Frank?
No, I did not.
Okay. And at some point, again, you spoke about the relationship starting to deteriorate in 2015, is that correct?
Yes.
Do you know, again, only based on your personal observations, not on anything told to you, do you know if a concern in the relationship had to do with Ms. Frank's infidelities?
Objection leading.
I'll overrule the objection.
You can answer that.
Yes.
And do you, again, not saying anything that was said, did you overhear a conversation between Mr. Eastman and Ms. Frank about the topic, generally?
Yes, I did.
Again, not saying what was said, but how would you describe the tone of that conversation?
From which perspective?
From your perspective.
From your perspective.
She had.
From your perspective, what was the tone of those conversations?
admission of infidelity.
Objection, hearsay.
Sustained. So the question is not what Ms. Frank said, it's what the tone wasn't. You know what tone means?
Yes,
Okay, so what was the tone?
a little confrontational.
Okay.
And just to clarify, what was Ms. Frank's tone?
Flippant.
And can you describe what you mean by flippant? Because I think my father would have said that I was flippant as a child, and so I think sometimes people have different understanding what that word means. So if you could just explain what that means.
Not using much regard for another's feelings.
Again, and throughout all my questioning, I just want to make sure it's clear, I'm not asking you any questions about anything that was said to you, just only on your observations, okay? Did the knowledge of Ms. Frank's infidelities appear to change how Mr. Eastman felt about her?
Not really.
Okay. Did you observe, would you say Mr. Eastman appeared, again, just behavioral in your observations, jealous or more resigned to Ms. Frank's cheating?
Definitely resigned.
Would it be fair to say, or how would you classify how much Mr. Eastman was a part of her life after that point going forward?
Of her life?
Yes.
He was still there.
Okay.
100%.
And were there times that you would visit the residence at 2167 West 35th Avenue Court in Greeley?
Yes, multiple times.
When you visited, was both Mr. Eastman and Ms. Frank living at the address?
Yes, they both were.
When you visited, did you make any observations about the dynamics of the relationship in the household?
Yes, I did.
And can you explain what those dynamics were?
What did you observe with your eyes?
A lot of a give and take, a relationship that perhaps was having a lot of problems. It was pretty rocky at that point. A lot of dissension.
And when you say give and take, can you be a little bit more clear in terms of what you mean by that in terms of the players or the people involved? Who was giving and who was taken?
Well, definitely my brother, to my observation, was giving and Heather was taking.
Okay. And at some point in the December of 2019 time period, did you let me take a step back. When was the last time you visited the West 35th Avenue court address in Greeley to visit Mr. Eastman and Ms. Frank?
It might have been early 2019. I can't recall because we were focusing on getting our house done, so we kind of stopped. We were remodeling our house.
Okay. Were you aware at some point in 2018 when your brother moved out of the address?
Yes.
Do you know when that was?
I would say August or September of 2019.
Okay. And do you know where he moved to?
Yes, would you like me to state kind of where it is?
Sure.
A little Victorian that had been converted into apartments down on 10th Street, I believe.
Okay. Is that here in Greeley?
Yes, it is in Greeley, I'm sorry.
And at some point around Christmas of 2019, did you become aware of the end of Mr. Frank and Mr. Eastman's relationship? I'm sorry, Ms. Frank and Mr. Eastman's relationship?
Yes, I did.
Foundation and hearsay.
I'll sustain the objection.
Okay,
I'm sorry. Go ahead. I thought she was talking. Go ahead.
Okay, I was like, you told me to wait and go at the same time. In beginning of January 2020, did Mr. Eastman come to live with you?
Yes, he did.
And did he come to live with you in Parachute?
Yes.
Do you know why he moved in with you?
He needed to get away from Greeley and Heather.
Objection, foundation, and hearsay.
So you answered that question based on what your brother told you?
No, personal knowledge as well.
Based on something other than what he told you?
No, not really.
So he told you this and that's how you're answering it?
Yes.
Sustained. The jury's not to consider that last statement. Let's try to elicit information that's not hearsay.
So when Mr. Eastman came to live with you at the beginning of January of 2020, did you observe his demeanor?
Yes, I did.
How would you describe it?
He was emotional, not very well put together, not his usual self.
Okay. Would you agree that he was a broken man at that time?
Absolutely.
And when he came to live with you in Parachute, did you observe him try to take steps to get settled in the area?
Yes, I did.
And what were those steps that you observed?
Making doctor's appointments right away to get back on his meds. Obtaining suitable employment to be able to help out financially. Helping me around the house with the remodel. Shuttling the grandkids to and from sporting, practices, school activities, honor roll breakfasts, those types of things.
Were you financially providing for Mr. Eastman at the time?
Yes.
And I believe you indicated he was working for a temp agency?
Yes.
Do you know doing what?
He was working up valley in Loma Springs, wherever they put him, but mainly as a carpenter for construction, home builders in Gloomwood.
And even though he was working as a temp agency, were you still having to pay for, or do you know if he was financially struggling?
Oh, absolutely.
Did you observe, or let me ask you this, how long was he living with you in Parachute?
From approximately January 5th, 2020 to the end of the first week of February 2020.
And at that time period, or during that time period, was there plans for your family to move to Pueblo?
Yes.
Did those plans include Mr. Eastman going to stay with you?
Yes, they did.
During that time period from January 5th, 2020 until the first week of February, did you observe any indication that Mr. Eastman was planning on going back to the Greeley area?
No, not at all.
Did you observe any indication that he was planning on reuniting with Miss Frank?
Not at all.
Foundation and hearsay. I don't know how you would observe whether or not somebody had intentions to do something.
So again, you could answer based on your observations, not what your brother told you. So can you answer that question just based only on your observations, not anything that your brother told you?
Yes, he was settling into the routine there at the house. We were making plans. He was helping us finish the remodel so we could sell the home to move to Pueblo where his adult son is.
Okay. Okay.
Long-term plans.
And did you have a rule in your house concerning alcohol?
Yes, I do.
Do you know your brother to be an alcoholic?
Yes, I do.
What was that rule regarding alcohol in your home?
I don't have alcohol in my home and I don't allow anyone else to.
And where does that stem from?
Alcoholic mother, and I'm raising my grandkids because my daughter is an alcoholic.
Was the no alcohol a strict condition of Mr. Eastman being and staying at your house?
Yes.
And you spoke about the progress that Mr. Eastman was making at the time, and getting a job, getting medication, etc. Did that all change come the night of February 7th, 2020?
Yes, I did.
That night, did you change the locks on your door? Or early that next morning?
Yes, I did.
And why did you do that?
Because I had indications that Kevin was out drinking.
And at some point, did you hear a vehicle return?
Yes, I did.
The night of February 7th into February 8th?
Yes, I did.
Okay. And did you look out the window and see whether or not that was your brother's vehicle?
I did.
And was that the silver Subaru Crosstrek?
Yes, it was.
And approximately what time in the night or early morning was that?
Approximately 2:30 in the morning.
Okay. And did you let him in?
No, I did not.
Why not?
Because I assumed he had been drinking, especially if he was coming in at 2:30.
Okay. And at some point the next morning, did you wake up? I'm assuming you did, you're here?
Yes, I did.
Okay,
I
that's
did.
good. Approximately what time that morning of February 8th did you wake up?
Around 7:30.
And did you hear anything outside in the driveway?
I peeked out. My husband said, Kevin Tanner are out there.
So without saying anything your husband said?
Okay.
Right? Did you hear Mr. Eastman's vehicle?
Yes, I looked out, saw it, and then heard it start up.
And you said you heard his vehicle start up?
Yes.
Was that around 7:30 in the morning on February 8th?
Yes, it was.
And did you watch the vehicle leave your residence?
Yes, I did.
And when the vehicle left the residence, did you have an opportunity after that point to see if Mr. Eastman had taken any of his belongings with him?
He did not take anything.
And let me be clear, the belongings that he had in your residence?
Yeah, he did not take anything to my knowledge.
Did he have a lot of belongings at your residence?
Everything he owned.
Did that include important personal, sentimental items?
Yes, it did.
Did you have any indication based on him leaving those personal items whether or not he was returning or planning on returning?
I knew he would return.
So again, based on Mr. Eastman leaving his personal belongings in your house, did you have any indication that he was going to Greeley?
None whatsoever.
And during the beginning of February of 2020, did you have access to your brother's email?
Yes, I did.
I'm showing what's been marked as proposed defense exhibit triple L. Pursuant to defense motion D94 and Colorado Rules of Evidence 807, we are seeking to omit this email. I showed Mr. Wren previously.
Any objection?
Based on previous litigation.
So, I'm sorry, what's that? It's, what exhibit number is that?
Triple L.
L is admitted.
Yes. May I approach this witness?
Yes.
And Ms. Brinklow, I'm showing you it's again marked and admitted as defense exhibit triple L. Do you recognize what that is though?
Yes, I do.
Is that or what is it?
It's an email from Heather to my brother Kevin.
And did you find that?
Yes, I did.
At this time, we would request to publish the email.
Sure. Would you like to proceed to do that?
Yes, please. And after the jury is done viewing the email, I am done with my direct examination.
Thank you. While we're waiting, could the party go on Bluetooth just for housekeeping issues? Do you need it? Okay. Mr. Run, you're welcome to conduct cross-examination.
Thank you. Good afternoon, ma'am.
Good afternoon.
You and I have not met, correct?
No, we have not.
Okay, we haven't talked on the phone or anything.
No, we haven't.
You, as was mentioned by defense counsel, members of the law enforcement investigation team in this case have tried to reach out to you at various times, correct?
Yes, they have.
Okay. Starting with, at the time, Detective Jennifer Fick of the Weld County Sheriff's Office back on April 7th of 2020, correct?
Yes.
And you talked to her for a while, but there was some hesitancy in the information you were willing to give her because you told her.
Objection, hearsay.
It goes to, it's not offered for the truth, but state of mind.
Okay, so for the jurors need to understand that the response to her question is not being offered for the truth of the matter asserted.
Okay. You were hesitant to give her complete information, correct?
Yes.
Okay. And you told her, I'm working with the defense team.
Yes.
Okay. And when she asked you some additional questions, you said that's up to the defense to share with you guys.
Yes, if you say so, yes.
Okay. Do you recall making that statement?
I probably made something very similar along those lines.
Because that was your mindset at the time, correct?
Yes.
You knew your brother had been arrested and charged with murder.
Yes.
You didn't know all the facts.
No, I did not.
You didn't know any of the facts, essentially, correct?
No, other than my brother had been arrested for murder, yes.
Okay. Had you talked to him about what had happened?
No.
Okay. The two of you talked through the jail phone system frequently, correct?
Yes.
Okay. But you didn't talk about what happened?
Not really. Everything's being recorded.
Okay. So he was unwilling to talk to you?
Your Honor, objection. This goes into Mr. Eastman's Fifth Amendment right and attorney-client privilege.
Don't.
To talk to a third party?
I won't say Fifth Amendment, but I will say it gets into confidential Sixth Amendment related information.
Not if he's talking to his sister.
Yes, I'll overrule the objection.
Specifically, do you recall a phone call with your brother on October 10th of 2020 at approximately 5:30 in the evening?
I don't.
There were a lot of calls.
Sure,
Okay.
sure.
And I don't, do you recall the two of you talking about jail staff and how they're hired and how they're not competent? Do you recall a conversation around those
Objection,
lines?
relevance.
I'm asking if she recalled the conversation in which that was talked about in order to place in context the remainder of the conversation.
Okay, I'll overrule.
Do you recall a conversation along those lines?
I don't recall that.
Okay. Do you recall telling your brother, "I wish it were different, Kev"?
In relation to,
The situation.
oh, I'm sure I said that.
And do you recall Kevin responding by saying, quote, "Yeah, me too, Shell. It's all because of my stupid errors in thinking. You know what I mean, but we'll get through it. I apologize to everybody for it happening, but I'm using the time to the best of my ability."
Sure, I'm sure that sounds just like Evan, yes.
All right. You just talked about an email that you saw on Kevin's account on January 18th of 2020. The email that we have in evidence simply has the subject line, is that correct?
Yes, it does.
Okay, it doesn't have anything in the body of the email? There's no content to this email?
No, there is none.
And is that the way that you saw it?
That's exactly the way I saw it.
So the only thing this entire email said were 4 words in the subject line, "Please talk to me."
Yes.
You don't know what precipitated that?
I could, yes, I do know.
Okay. Well, were your brother and Heather reconnecting on email at that time?
No, he had, upon my advice and me watching him, we blocked Heather on social media and phones.
You didn't like Heather, fair to say?
I did like Heather in the beginning. Yes, I did like Heather.
In January 2020, you were not a fan.
Oh, probably not, no.
Okay. And so along comes February 7th, and you're reading between the lines and looking at the circumstantial evidence as well, and had deciphered that Kevin had been out drinking. Is that right?
I assume so, yes.
Based on what?
Past behaviors.
Okay. Is that the fact that he came home so late?
It's the fact that he even left the house when he had been staying home all the time that he was with me.
And then you saw him drive away in the early morning hours of the 8th, is that correct?
Yes, I heard him and observed the vehicle leaving, yes.
Right. From your house?
Yes.
Did you try to get a hold of him?
I knew he didn't have a phone.
Okay.
Active service.
He had a phone, correct?
But he didn't have active service.
In other words, you couldn't call him.
No.
And you couldn't text him.
No.
But he had a means of communicating through Wi-Fi when Wi-Fi was available, is that correct? In other words, you could communicate with him.
I'd ask for one question followed by one answer.
Yeah, what, so your objection is compound question?
Yes.
Let's break it down then.
Sure. You could communicate with him by Facebook on his phone, correct?
Yes.
And you tried to reach him that way on the 8th, correct?
I don't think I did because I assumed he was coming back.
Okay. At some point, you told one of your other brothers, Ron, that you were considering putting out a missing persons report for him. Is that right?
Yes, I did.
Okay. Was that on the 8th?
No, that was not on the 8th.
Is that on the 9th?
That was not on the 9th.
When was it?
Monday, the 10th.
And in fact, you did have Facebook communication with Kevin on Monday, the 10th, correct?
I believe so, yes.
Now, if the Facebook records indicate that on the 8th, you sent a Facebook message saying, "Where are you? I'm worried, just touch base with me, please." Would that be accurate?
Oh, okay, yeah, if I did, yeah, I'm sure that sounds like exactly what I would say.
Okay, so you did try to reach out to him on the 8th?
I guess I did, yeah, I didn't remember that.
And he didn't respond?
I don't believe he did.
At all on the 8th?
No.
Correct? And there was no communication at all on the 9th, correct?
No.
And then on the 10th, you said, "Hey, are you okay?" Correct?
Yes.
And he responded with, "Yeah, I'm fine."
Yes.
And that was about 10 o'clock in the morning on the 10th.
Very close to that, yes.
And that's the first time you had heard from him after he had left your house on the early morning of the 8th, correct?
Yes.
And that was unusual at that time,
Unusual for,
the relationship between the two of you.
not really.
Well, you described this scenario where you were essentially playing mother and you were making sure he was staying home and
Yes.
therefore you and he were communicating constantly.
Yes. Yes. But it was not unusual.
Well, if he was staying home, the two of you would be communicating constantly, correct?
Yes.
And so at that time, for you not to be communicating constantly was unusual.
For that time period, yes.
All right, you said that he left a lot of his things behind at your house in Parachute, is that correct?
Yes, he did.
Okay. Did you see what he had with him in his car?
No, I did not. On the date, the morning he left?
Yes.
No, I did not.
And you said at that time that he was with you, you described him as being a broken man, is that right?
Yes.
And he was frustrated by the fact that he wasn't making much money while living at your house?
I wouldn't say frustrated, I'd say disappointed.
Okay. Is there a big difference in your mind?
Frustrated would indicate to me anger, agitation, and that's not how he felt. He felt immense guilt at not being able to bring in the money that he used to, and there I am, living at his sister's. He's living in his sister's home.
And that was part of why he felt like a broken man?
That's not all of why. That's not the main component at all.
The other component was that a relationship that he had been invested in for a long time was over.
Yes.
And he was financially struggling.
And I'm sorry?
And he was struggling financially.
Yes.
He was desperate at that time.
I wouldn't say
Objection,
desperate, no.
speculation.
So I think she answered, yes or no?
No. Yeah.
He was a broken man, but not desperate.
Not desperate.
You said on direct examination that the relationship that you had observed between Heather Frank and your brother was a rocky one, correct?
Yes.
And you described it as being full of dissension?
After a certain period of time, yes.
Okay. Did you ever see your brother physically harm Heather?
No, I did not.
Okay. How often were you around the two of them?
Every other month for the length of their relationship, weekends at a time, staying in the home.
So approximately 6 time periods a year?
Full weekends, every time we came through this way. I mean, it could have been every month. I have so many pictures of all these times.
Okay. Did you see bruising on Heather in any of those pictures?
Never.
On the occasions where you would visit, would Kevin remain sober?
Oh, yes. Yes, he would.
And he was a different guy when he was sober, would you agree?
I think most people that are alcoholics are, yes.
So you didn't observe the nature of their relationship when he wasn't sober?
No, I did not.
Because he knew you wouldn't approve of him being in that condition?
Yes.
Okay, so when you were around and you were visiting Heather and Kevin in Greeley, those were times when Kevin would have been on his best behavior?
By not drinking, I can say that Kevin was not drinking.
When you were around?
When I was around.
Okay. If I could have just a moment, Your Honor.
Sure.
Ms. Brinklow, the night of February 7th, is it your testimony that that was the only night that Kevin and your son Tanner went out drinking?
Yes.
While he was living with you?
Yes.
Okay. He had previously threatened Tanner while drinking, correct? While at your house?
Objection, 404B, relevance. I'd ask the court to instruct the jury to strike that.
Yes, the jury's not to consider that last question. Let's move on.
If I could retrieve a couple of students.
Yes.
Can I please see?
Okay, just a second.
Just this one? Just that one? Oh.
May I approach her?
Yes.
Let me ask a couple of questions first, if I may, ma'am. Are you familiar with a staffing agency by the name of Rifle Works in Rifle, Colorado?
Yes, I am.
Okay, how are you familiar with it?
It's the only temp agency in Rifle, I believe.
Okay. And is that close to Parachute?
Approximately, yes, 20 miles.
All right. And while Kevin was with you, there was an effort on his behalf through the court system to collect a settlement of some type. Is that correct?
Objection, relevance.
Mr. Rowe? Oh.
It speaks to information on People's Exhibit 78, if the court wants to view that.
Can I take a look again, please? So I'll overrule the objection. You can answer.
Kevin was pursuing an unemployment insurance claim, correct?
Yes, he was.
Okay. And was there an appeal that was related to that claim?
As far as I know, yes.
No further questions. Thank you.
Thanks. Any redirect?
No, thank you. No, thank you to Mr. Wren, but yes to the court's question. Steve, I think you left something. Ms. Brinklow. Okay, so let's talk about the big elephant in the room. Mr. Wren asked you or said you weren't a fan of Ms. Frank.
Yes, he did ask me that.
Why weren't you a fan of Ms. Frank towards the end?
the relationship had deteriorated so badly that I was concerned for Kevin's mental health and well-being.
And he also asked you about whether Mr. Eastman was on his best behavior around you when he was sober.
Yes, he did.
Those times that you were around towards the end, was Miss Frank sober around you?
No, she was not.
And was that a point of contention or strain between your relationship with Miss Frank?
Yes, it was a big source of contention.
Why?
Because I come from an alcoholic family, and my brother is an alcoholic, and I feel all the activities that we were doing were kid-related and didn't require alcohol.
And was it frustrating to you that she wasn't respecting that?
Yes, very frustrating, knowing my stance.
And Mr. Wren also asked you about a jail phone conversation in which, again, context is everything, but I apologize for everybody for it happening, meaning, well, let me ask you this way. When Mr. Eastman was arrested, did it affect your family? The act of him being arrested?
Of course it did, yes.
How so?
The loss of my brother to incarceration, losing Uncle Kevin for my kids and grandkids. It was like a hole in our family.
Nothing further. Thank you, Ms. Brinklow.
Any recross?
No, Your Honor.
Any questions from the jury? Thank you. Welcome to step down. We appreciate your time. We have time for a very short witness if one's available, but
We do. At this point, we would release Ms. Brinklow. I don't believe she's under the government subpoena, so I would ask the court for permission for her to be able to stay now.
do you agree, Mr. Wren?
Yes.
Thanks. You're welcome to stay or go. It's up to you. And let's put on, if it's a very short witness, we can have that very short witness testify.
At this time we would call Deputy Scott Chambers, please.
This will be the last witness for the day. Good afternoon, Deputy. Thank you for waiting. Thanks for your patience. I can please have you come on up to the witness stand and I'll swear you in before you sit down. And do you solemnly swear or affirm under penalties of law that the testimony you're about to give will be the truth? Thanks. Why don't you have a seat, make yourself comfortable. Feel free to adjust that microphone. Once you're settled in, if I can please have you introduce yourself to the jury by stating your name and spelling your last name.
My name is Dennis Scott Chambers, Chambers.
Thank you. Welcome to examine.
Thank you. Mr. Chambers, this probably is obvious, but what do you do for a living?
I'm a deputy with the Will County Sheriff's Office.
And how long have you been a deputy with the Weld County Sheriff's Office?
I've been with the Weld County Sheriff's Office for 14 and a half years.
Did you have any prior law enforcement experience?
I do. I started full-time back in 2000 down in a small town of Rocky Ford. And then was there about 3 years and then moved up to the small town of Berthoud before coming over here.
And so, in what capacity are you a deputy with the Weld County Sheriff's Office currently?
Currently, I'm assigned to the detentions division as a canine handler.
Do you have a dog?
I do.
What's the dog's name?
The dog's name is Ranger. He's a 3-year-old lab.
Okay. And were you employed at or let me ask you this, were you working on February 17th, 2020?
I was, yeah.
And were you assigned or asked to go to the address of 267-112 County Road 45?
I was.
And when you arrived at the property, what was your role?
I'm assigned to the small unmanned aerial systems program. So it's basically the drone program.
And did you have any training or experience to be able to play with a drone as part of your role?
I do.
Or job, I should say.
I'm not sure if play is the right word, but.
I'm certified with the FAA as a Part 107 pilot back in 2017.
And what does that mean for us non-FAA drone flyers?
It means that we've got extra training, knowledge. We've gone through a certification process to follow all of rules in the airspace.
So even though it's a drone and you can buy it at Walmart or Target, I'm sure yours is fancier, but is it fair to say that the FAA also governs, even though it's not a plane, it governs drones?
Yeah, they do.
Are they equally as strict with drones as they are airplanes?
Yes.
Okay. And so to be certified, what did you have to do?
We started out with a manual to learn all the FAA rules and regulations. And then once we were comfortable with the materials, we took a lot of the practice tests that were online or within the manual itself. And then we had to set up a certification test. We went through over to Ames Community College and did the FAA test then.
And why do you have a drone, or in what capacity do you use a drone as a deputy with the Weld County Sheriff's Office?
With the Weld County Sheriff's Office, we use the drone for quite a few different purposes. One is evidence collection, search and rescue, documentation of traffic crashes, that type of capacity.
Why is a drone helpful in doing evidence collection?
For the drone, it gives an aerial view, a little bit more of an overview. At least with our agency, that's what we use it for.
And is it helpful to use when conducting a search warrant on a larger property?
It gives that perspective of the overall property itself. We've got limitations. We can only fly up to the 400 feet maximum. So we go about 399 right at 400, and we can go down to ground level. So it gives that unique view of real time on the property.
And are you able to zoom in with the drone?
The one I used that day is a Phantom 4 Pro. That camera does not zoom.
Okay. And when you say that day, do you mean on February 17th, 2020?
Yeah, the 17th and the 18th.
Okay. And were you still able to take photos or any type of video of the property to assist in the search?
I was briefly on the 17th and then followed up on the 18th.
And did you provide those overall views to assist other members of law enforcement conducting the search?
Those are provided to the investigators that are on scene.
And you indicated your work in this case expanded or crossed into February 18th, 2020?
It did.
And can you explain to the jury what you did on that day?
On the 18th, I arrived back to the scene. To start off, the very first thing in the morning, we met up at the fire station at Platte Valley Fire. They wanted to look at an area on County Road 61, which was an area of a bridge. I met up with Deputy Ong. He briefed the fire guys of what the operation would be, looking for an object. We left there, went over to the bridge on County Road 61, south of County Road 388, which is just, the bridge is also north of Highway 34. That day, I flew that area based off of some information that I was told by the investigators. They wanted aerial photographs of that bridge area while the fire guys were conducting their operation.
And in that kind of situation, why were firefighters brought into an area of the bridge? I assume there was no fire?
No, the firefighters of Platte Valley Fire are trained specifically for like swift water rescue and water operations. And they were requested to help in searching for potential evidence.
And was any evidence ultimately located at that river scene?
Not while I was there.
Was there, and while you were there, did you observe any signs of blood anywhere?
Not that I am aware of.
Did you observe any signs that would indicate a struggle took place there?
Not on the bridge, no.
Did you observe any type of firearm on that scene?
No, I did not.
Did you observe any type of knife on that scene?
No.
Did you observe any type of spent casings?
No, I did not.
Nothing further, thank you.
Any cross-examination?
Was there water in the river at the time?
Yes, sir.
Was it flowing?
Yes, it was.
Okay, no further questions.
Any redirect?
No.
Any questions from the jury? Other than, can we go home now? Thank you. You're welcome to step down. Okay, we are going to recess for the day.
And Judge, Deputy Chambers is released as well.
Thank you.
With
Any
the
objections,
thanks.
Mr. Wren?
No.
Thank you. You are released. Okay, so thank you again for your attention and dedication to this case this week. We appreciate you being here. And I don't say that lightly. We do appreciate you being here. So we're going to resume this trial on Monday. I would like to get started at 8:30 in the morning. Once again, I want to give the admonition that until the trial is completed, you must not discuss this case with anybody. That includes your family, people involved in the trial, including witnesses, other jurors, or anybody else. If somebody approaches you and tries to discuss this trial with you, let me know about it immediately. It's also important that you must not read or listen to any news reports of the trial. I'm telling you that they're out there, and so now that you're aware of it, please make efforts to avoid reading or listening to any news reports on the trial, whether they're on paper, on the internet, or other forms of media. Please don't do any independent research, including researching on the internet, medical or law books, or dictionaries. Finally, it is especially important that you not form or express any opinion on the case until it's finally submitted to you, and we'll see you Monday at 8:30 in the morning. Let's all please rise for the jury. Okay, you're welcome to be seated. Let's see, we're outside the presence of the jury. It's 4:52. Any issues before we recess until Monday?
I just want to let the court know I'm going to be a little bit late on Monday morning. I have an 8:15 with Judge Kearns on a revocation finding that he has to make and of probation, and it's kind of it was a lengthy probation revocation hearing, so I
You
really
wanna-
need to be there.
Are you saying that you want me to start without you, or do you want me to wait for you?
Well, I think that Mr. Ryan can handle it, I'm pretty sure.
Okay. Okay, anything else?
No, I just wanted to let the court
Okay,
know.
appreciate that.
No, sir, thank you.
Okay, I'll take those Bluetooths and we'll recharge them for the weekend. And have a nice weekend.
You too, sir.
Thank you.
I assume you're not on bond hearings again?
No.
So you can actually have a weekend?
Yes. Is there any evidence that was not admitted that's here?
No, it was all previously admitted evidence.
Okay.
And I don't see anything over here.